ಇದು ಸೆಟ್ಲ್ಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಯಾವ ತರ ಒಂದು ಸೆಟ್ಲ್ಮೆಂಟ್
ಟೋಟಲ್ 18 ಮೆಂಬರ್ಸ್ ಮಾತ್ರ ಕೊಡಿ
ಮೇಡಮ್ 18 ಮಂಡೇ
ನಮ್ದಾದ್ರೆ ಮಾತ್ರ ಇಟ್ಕೊಂಡಿರಿ 18 ಕೊಟ್ಬಿಡಿ 18 ಮೆಂಬರ್ಸ್ ಕೊಟ್ಬಿಡಿ 18 ಮೆಂಬರ್ಸ್ ಕೊಡಿ ಸರ್ ಅವ್ರು ಡೇಟ್ ಕೊಡ್ತಾರೆ
ಅರ್ಜೆಂಟ್
ಕೊಡೋದಾದ್ರೆ ಕೊಡಿ ಇಲ್ಲಾಂದ್ರೆ ಬಿಟ್ಬಿಡಿ ಟೋಟಲ್ 18 ಮೆಂಬರ್ಸ್ ಕೊಡೋದಿದ್ರೆ ಕೊಟ್ಬಿಡಿ ಸರ್ ನಮ್ದು ಮಾತ್ರ ಇಟ್ಕೊಂಡಿರಿ ಮೆಂಬರ್ಸ್ ಕೊಡ್ಬೋದು ಸರ್
ಮೇಡಮ್ ಇದೊಂದು 18 ಮೆಂಬರ್ ತೆಗೆಬಿಡಿ ಮೇಡಮ್
ಅಲ್ಲ ಅವರು
ಮೇಡಮ್
ಫೈನ್ ಸಿಕ್ಕಿದ್ದಾರೆ
ಟೋಟಲ್ 18 ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಮೇಡಮ್ ಟೋಟಲ್ 18
ಸರಿ ಕೊಡಿ ಆಯ್ತು ಕೊಡಿ ಮೊಬೈಲ್ ಮೆಸೇಜ್ ಬರುತ್ತಲ್ಲ ನಾನು ಪೋಸ್ಟ್ ಆದ್ರೆ ಅವ್ರು ನೋಡ್ಕೊಳ್ತೀನಿ Wait, kindly wait, madam. Let madam come. So that is started and go to only one match. I'll hold it.
My lord, my lord, typographical error in the order, my lords, passed by this honorable court. May be listed on Monday, my lords, for being so.
for settlement ಮೇಡಮ್
File all the.
My lord, total 18 memo, my lord, fresh matter. My lord, under Atrocities Act, FIR has been filed, my lord, there's urgency, maybe posted on Monday, my lord.
File it.
Monday,
Photo number 18, my lord.
Monday.
It's not the, I moved the memo. Date is not given, not the principle, the word.
Yes.
Monday, my lord.
Monday may not be possible, sir. Let me see. At the earliest, it will be listed.
My lord, photo
18, photo number 18.
Settlement,
This, file it.
settlement matter, my lord.
File it.
23, 24 ಇಲ್ಲ ಅವ್ರು
Don't insist for Monday.
ಹೇಳಿಲ್ಲ ನಮ್ಮ
No, my
It
lord.
will be listed at the
If it
earliest.
is today afternoon 2:30, it would be great because.
2:13,
today-
nothing. Next, compromise ಇರೋದು, settlement ಇರೋದು immediate. Not today.
Similar request, photo on 18,
Hmm.
was listed today. I have been approaching the court since the vacation. I have no other alternative. Committee kindly heard me today afternoon. It's a very important present.
No, it is not listed today.
They listed
Date
on
was
photo
given?
18, but the honorable.
Maybe whether date was given, ನೋಡಿ ಅದು ಯಾವ್ದು ಅಂತ ನೋಡಿ. ಅದು ನೋಡ್ಕೊಳ್ಳಿ, ಹೇಳ್ಕೊಳ್ಳಿ. Yes, I'll verify, sir. I'll wait.
Photo 18 matter, my lords. Fresh matter. May I have it on Monday? There's urgency in the matter.
You file it. I'll see to that it will be listed at the earliest.
Yes.
Next. Over.
Any adjournment? List to page 4, serial number 19 to 24.
Lordship, serial number 19, 1 week time may be granted.
2015,
Yes, my lordship.
oldest matter.
Because my lordship, I filed the new Wakalat, my lordship, I have not received the record from the other side.
You are for the respondent.
Yes, my lordship.
Louder. Let me see. Let the appellant address the argument.
My lords,
Already addressed.
already addressed.
Yes, my lordship.
Then
My lord, serial number 21, my lords.
Huh?
I had applied for certificate copy. I received 21, my lord, second list.
my lord,
Yesterday, I have received it to Unsur, my lords. There are 8 NCRs and 2 498 cases. I have received the documents, my lords.
My lord, they are keep on taking time, my lord, since so
12
many
date
days
maybe
they are
12 minutes.
giving
I
the
will
same.
complete.
Wait,
Please don't
wait,
adjourn the matter,
wait.
my lord, we are ready to argue.
wait for some, let it come. I'll consider. Let it, next.
List one, sorry, list four. Provision court matter. Serial number one, Mallana Gowda.
This one. Also, this one.
List one, page one. Serial non-compliance of office objection for first time. Serial number one, Shilpa Rani.
Kindly give for 1 week.
Counsel for the appellant, praise for time, list on.
Two, Onkara KB.
Date, madam.
When counsel for the appellant is absent, no representation, list on.
Three, Madhukar M. Deshpande.
For the appellant, my lord. I pray for 1 week's time, my lord.
Next,
Four, Aparajita Arika.
For appellant, pay for 2 weeks time.
list fine. Yes,
Five, Vijay Shekhar Gowda.
absent, no representation.
Six, government advocate.
Praise for time,
Seven, S. Rashekar.
absent, no representation.
Eight, H. Prakash.
My lord, I have some submissions, legal submissions. Officers raised the objections that I should go for a criminal petition. In respect of that, I have filed my legal submissions, but it has not come. I'm ready to submit my submissions.
Can update.
I have filed a criminal appeal.
1 minute, 1 minute. Fair enough. Which is the order you are impugning?
My lord, I am questioning the order of bail cancellation application I have filed under section 439. That application was rejected by the lower court. I am asking for the cancellation of the bail of the accused.
Hmm.
Because the series of violations have taken place
Hmm.
in obtaining the bail by the accused in front of law. From the stage of police investigation,
Petition for seeking cancellation was dismissed.
seeking bail cancellation,
Was
that
dismissed.
application I filed under section
That
439,
application was dismissed.
dismissed.
Ah.
It is in a peremptory nature.
Yeah, what is your submission?
My lord,
What is your submission?
yes, my lord, the office has raised the objections that I should go for criminal petition
Hmm.
instead of criminal appeal.
Yes,
My lord, in this my appeal, the victim
Hmm.
is filing the appeal.
under
So,
which provision of law?
yes, I have invoked section 372 of CRPC, read with section 386 of CRPC.
372,
My lord,
372.
plus read with powers of appellate court, section 386.
First, you have to convince 372 is applicable.
Yes, my lord. Actually, the law is contemplating 3 types of appeal. First type of appeal is against the conviction. Second type of appeal against acquittal. The third type of appeal, first, second, and third, both are joined in section 376.
370?
My 386 CRPC. All these types of appeals have combinedly put together in one section. That is,
It is neither than a conviction nor an acquittal.
yes, my case is
Hmm.
386D.
86 is only a power of appellate authority.
Yes, I'm invoking that power because section 372 is reserving the power of the victim to file an appeal in section 372. Kindly see, my lord. It says, provided that in section 372 proviso.
No, you cannot leave the first portion of 372.
No, what I'm submitting is, the law is,
It refers to the judgment of the criminal.
yes, my
not
lord,
the
here,
the order.
no, here, what I'm saying is, section 386, it is covering all these three.
Telling you 372 refers to the judgment.
Yes,
to-
but there, my lord, in section 386, there is a provision showing that comma, plus, that means along with. That means the appeal against conviction, the appeal against acquittal, then appeal against any peremptory order in the nature of peremptoriness.
Where-
I am invoking 386D.
Hmm.
In an appeal, the victim of the crime can file an appeal for any other order. Law is saying any other order. But the only qualification I think, in my personal opinion, it should be in the peremptory nature. So any order in which the appellant is seeking the relief of alteration or reversion of the order in the impugned order passed by the lower court. If I have any grounds, then my lord can interfere in that order and reverse the contents of the impugned order or alter the nature of the order. Because in the order passed by the lower court is saying the bail granted by this honorable court is not appearing innocuous. It is innocuous. It is not coming in the way of investigation.
It is an order. You are challenging the order passed by the trial court,
Yes, my lord.
right? It is not a judgment.
Yes, my lord.
So you cannot invoke section 372.
No, I am invoking 372 plus 386.
Even 386 refers to section 377 and 378.
And also coming to.
And it also refers to the judgment,
and also refers to in
to
386
the orders.
ED, D.
No, you
In
have to
an
present
appeal from any order.
No, nothing. I'll reject your submission.
Because one submission. In the impugned order, the trial judge is saying the bail granted to the accused is innocuous. It is not coming in.
Maybe, whatever may be the reasons assigned by the court, it
Ah.
is an order.
Then if injustice, unlawfulness, wrongness is contained in that order, I have a right to question it before my lordship.
You have a right, but
Hmm.
not by way of an appeal. That is
My
not
lord,
the objection.
My lord, the provision I am invoking.
Your right to question the order is taken away, but not by way of an appeal,
My lord, my submission is,
because it is not a judgment of conviction or acquittal.
my lord, my submission is 386D is saying very clearly, the Honorable High Court
Yes.
in an
I
appeal.
heard. Yet the word. Third learned counsel for the appellant on office objection regarding maintainability of the appeal. Peruse the curatory memo filed by the appellant. The next part, the appellant is impugning the order dismissing his application filed under section 439(2), seeking cancellation of the bail granted in favor of the
My
respondent.
lord, my submission is also taken, my lord. I have filed that my submissions also,
Is contended that
written submissions.
petition appellant is invoking section 372 read with section 386 of CRPC. The appeal referred to in those provisions of law refer to the judgments of either acquittal or conviction, not to the orders passed by the trial court. Hence, the submission of the learned counsel for the appellant is rejected. Office objection regarding maintainability of the appeal is accepted. Accordingly, the appeal is dismissed with reserving liberty to the petitioner appellant to challenge the impugned order in accordance with law. Yes. Office objection accepted.
My
Appeal
lord,
is
I have filed
dismissed.
one written submission on
Yes.
3rd October.
I have referred to it.
Yes, ma'am.
Next.
Yes, ma'am.
Serial number 9. Srikant MP.
Appearing for the appellant, my lord, kindly have 2 weeks time to my lord.
Praise for time.
10. Appana Gowda.
Praise time.
11. Vinay Mahadevaya.
2 weeks time may be granted, my lord.
Praise time.
12. Government Advocate.
2 weeks, my lord.
Praise time.
13. Government Advocate.
Same.
Praise time.
Non-compliance for second time. Serial number 14. Government Advocate.
Praise time.
Pray for time.
Narayan Swamy.
We are appealing for the petitioners before that, Milan. It is pertaining to the railway matter. The time of filing of the criminal appeal, we are in the panel, Milan. Later, we are not in the panel. Have handed over all the files to the department.
Whether you have informed the appellant,
Please, Milan, all the files has been taken by the
whether
department.
with the endorsement.
Check.
No, you have to
And-
communicate it to the
Please,
appellant.
please. And in all the railway matters, ASG is appearing the railway.
Let him file. Bring him. Ask him to appear.
2 weeks time may be given.
No, sir,
I will
pass
inform
over.
to the,
Otherwise, your memo will be rejected.
please,
Ask him, what is the
Please.
difficulty? Let him come
Please,
and
please.
undertake.
please, Milan, I will
Yes.
inform to the center. Because railway matter, railways has
I
been
understand.
merged
Let
with-
him come.
Please,
The panel advocate, let him come and undertake.
please.
16. Madhusudanes.
Absent, no representation.
17. Tejas KB.
Absent, no representation.
18. BS Prasad.
1 week time to complete the
Yes,
office objection.
Yes,
19. Swamy MM.
absent, no representation. Next,
20. Rupesh R.
absent.
Non-compliance for third time. Serial number 21. Vanishri J.
Finally, then counsel for the appeal is absent, no representation. Appeal as of the year 2020, listed for the third time. No reason, finally as the last chance. Next,
Serial number 22. D. Manjula.
Worship for the appellant, since Manjula is not a panel now,
Hmm.
kindly change the name from Manjula to K. Prasanna Shetty. madam.
Prasanna,
K. Prasanna Shetty.
he will appear.
Yes, my lord, sorry.
Learned counsel submits that, learned counsel. Prasanna Shetty,
K. Prasanna Shetty.
K. Prasanna Shetty submits that. He represents the appellant. As a learned counsel, D. Manjula is not in the panel of the appellant. Submission is placed on record. Office is directed to remove the name of so and so, show the name of so and so. Counsel for the appellant prays for time to comply with the office objections. Appeal is of the year 2021, listed for the third time, list finally as a last chance. Finally, a chance is given to comply with the office objections. Next,
23. Manjula D.
same,
Yes, ma'am, same.
no further date. It is posted finally. Look into the objections.
Please.
Pass over, first portion, Hakiri. So the name of so and so.
24. Rennie Sebastian.
For the appellate in this case. 1 week's time. A week's time.
Finally as the last chance.
25. Mr. Giridhar.
Then no representation, finally as the last chance. The full appeal.
26. K. Lakshmikant.
Finally, next.
Compliance for fourth time. Serial number 27. Rajaram.
And for the appellant, my lord, with time may be granted, my lord.
Finally, pass over, look into that. It is posted finally, then
28. Srinivasan P.
For the appellant, my lord,
Hmm.
a week's time may be granted. madam.
counsel for the appellant place for time. Release of the year, finally as the last chance. No
29.
further adjournment will be given. Next,
A week's time.
same. Next,
30. Nageshes.
Lord, I have complied to office objection, my lord.
complied.
Yes, my lord.
further. Still, there are objections. Verify, pass over. I will pass over the matter.
31. Pramodar. Hariprasad.
Matter, my
MP.
lord.
Appearing for
The
opponent.
office objection with regard to the maintainability of the appeal, my lord.
Hmm.
Here with regard to the fact that only the finding with regard to the check was given to by me.
to the complainant is that finding has been challenged, my lord. But it is a case of acquittal. We have only based on the debt is barred by time, my lord. In other aspect, the point number 1 is the finding, my
Accused was acquitted, is it?
acquitted. I am the accused before the trial court. He was
You are the
acquitted.
accused.
My lord,
You are the,
I am the accused before the trial court. I was acquitted only on the basis of the time barred debt, my lord. My humble submission is that the point number 1, where the complaint has proved that the accused has borrowed a total sum of rupees 6,90,000, my lord. There is no transaction between the complaint and me, my lord. There is no check was given to her. That is misuse of a check. That finding is
under
there.
which provision you have referring the appeal?
The provision, my lord, the provision that has made out is
I think when you.
378, my lord.
3. I think you can challenge such finding only when the other side challenges the judgment.
Other side has also filed the appeal, my lord. That
In
is the
connected
appeal number,
matter
my lord,
notes.
connected appeal number 310 of 2023. And it was connected as you can that.
Nearly the 378, where is the provision to prefer an appeal?
Against acquittal, my lord.
Against the acquittal, the complainant or the state government can prefer an appeal.
378.
Even the victim can prefer an appeal. Where is the situation for the accused to challenge the judgment?
Challenge with regard to the finding only, my lord.
Where it is contemplated?
Though it is not contemplated, my lord, when it
There
is a
is some-
judgment for acquittal, my lord,
I
378,
understood, sir, I understood.
it is that provision would
Whether
apply.
that contingency is not addressed under CRPC.
Suppose, my lord, in case the appeal of the other side has been allowed, my contention with regard to those finding cannot be looked into, my lord. So
That is why I am asking you whether that contingency is not addressed under CRPC. There is no provision.
I will look into that and I will.
Under CPC, there is specific provision.
Yes,
Similar to that, under CRPC, which is the provision?
that I will look into that and I will. do.
You have to make some research. Sir.
Yes, ma'am.
Counsel for the appellant, prays for time. To make his submission regarding the office objection about maintainability of the appeal. List finalize the last chance. Next.
32. Joshua.
Lords, I appear for the petitioners in this case.
Yes.
The office raises an objection despite the fact the trust, which is headed by the deputy commissioner, this is a Parsi trust in respect of the Parsi symmetry. The trust, they are the de facto complainants, the trust and its president. Despite the fact that they have been, it has been brought to the notice saying that both would have to be made parties, they raise an objection saying as to how the trust could be a first petitioner in the matter. Lords, today the trial court has posted the matter for the purpose of proceeding with the case on merits for hearing arguments.
Which is the office objection at serial number 3, is it?
Yes, my lord.
Yes, my lady.
Seal number 3.
No,
Three. Petitioner's name and address does not tally with the charge sheet.
That's all, because the
In
name
the
is not.
charge sheet, sorry, go ahead. My colleague is there. He will just mention with regard to the,
My lord,
in the charge
my lord,
sheet,
Parsi symmetry name is not mentioned.
Hmm.
The president name is mentioned in the charge sheet.
Hmm.
President is the authorized representative of the trust.
Hmm.
That is the submission what I have written, my lord, because the trust was a complainant. Trust is represented
Stated so in the petition
as we have stated so
paragraph.
in the petition in paragraph.
Which paragraph?
In the first paragraph, the petitioner, my
this
lord.
paragraph itself he says.
No.
Paragraph
You
4.
have to say in the charge sheet only the trustee in his personal capacity is mentioned. His name is mentioned, is it?
No, we have mentioned both the parties as both the persons as made as a parties to the proceedings, my lord. Trust as well as the president in the individual capacity, who is at CW1 in the charge
Trustee
sheet.
is accused number?
Yes, they are not the accused, they are the complainant, de facto complainants.
Complainant. You are referring to the respondent.
No. Petitioners.
Complainant.
Petitioners are the
Yes.
complainants.
Complainant's petition.
Petition number 2 is the charge sheet of witness.
Where is the complaint?
It's a complaint page numbers.
Page number?
The page number of the complaint.
Huh?
My lord, 7 minutes.
You don't have the file.
Yes, it's,
Ladyship, the file is with me. The
Oh.
complaint,
Is it page number?
it is at page number 43.
Forty-three is the summons, sir. Copy of the summons.
I'm sorry, my ladyship, it is Annexa 4. Annexa 4, page 43. 43.
Pass over.
Passover,
Look into that.
the Passover.
Pass over. Yes.
Number 33, Suresh Subbiah, 7 minutes.
Pass over.
34, Krishnan Karke,
Absent, no representation. Ella haki. Finally as the last chance. Next.
35, MS Chandrasekhar Babu,
Yes, I appear, sir.
The for the complainant is before the court challenging the acquittal of the offences are grievous in nature, non-bailable. In the police station itself,
No, what is the objection, sir?
objection, respond number
3 and 4. Why?
3
they are
and
made
4 has
part?
been acquitted in the lower court. They are the,
Why they are necessary? Are they necessary? part?
they are the culprits. In the complaint, I have clearly stated, they are the persons who have assaulted the petitioner complainant and their wife and
Judgment of
children.
acquittal.
ಹೌದು ಇದರಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ ಅನೆಕ್ಷರ್ ಇ ಪೇಜ್ ನಂಬರ್ 28 ಜಯಚಂದ್ರ ಸೆಕೆಂಡ್ accused number 2 and Shilpa, they are the daughter and son-in-law of the
2 and 3.
2 and 3.
No, Shilpa is accused number.
Accused number ಇಲ್ಲಿ in this case we have made accused number 2, respond number 2. They are the
Sorry, sir. Accused rank ಏನು?
accused rank number 2 is accused number 3 ಇದರಲ್ಲಿ
Accused number 3 is.
accused number 3
respondent number.
ಇದರಲ್ಲಿ in CC number 706 of 2000.
ಅದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ನನಗೆ. Respondent number 1 is Mr. Jayachandra.
ಹೌದು
He is accused number 1.
ಹೌದು
And who is Shilpa?
Shilpa is his wife, accused number 3 in the lower court. And in
You
this,
have mentioned in the cause title, Dhanush as accused number 3.
Dhanush is the son of the Venkatramanappa.
Whoever he may be.
He is also,
Rank as an accused.
ಹೌದು what the rank of the accused is, in the complaint it is there. What had happened in this case? We have made complaint.
Asking you anything. I am asking you the rank of the respondents as accused.
Respond number 3.
According to you, Jayachandra is accused number 1.
ಹೌದು
And what is the rank of Shilpa, respondent number?
respond number 3.
And why you have respondent number?
Dhanush is also one of the son, or he is in the complaint.
Son, wife, father.
ಅಲ್ಲ,
I'm
in the-
not bothered about that.
I request my lord to look at the complaint.
Pass over.
Complaint ಅಲ್ಲಿ it is there.
Pass over.
It is clearly stated, Dhanush is the necessary party.
Pass over, please come.
Right. I will convince.
number 36, Srinivasa,
Let's, fine, clear, 1 week time,
Waste the time, finally as a last chance.
2 matters. Correct.
Finally posted. Next.
non-compliance for 6th time, serial number 37, B.S. Prasad,
Only pass on, only one objection, I clarify.
Pass over.
for order, serial number 38, Abhinav Vaiti,
ಏನಾಗಿದೆ?
It is not at
Sorry.
resume.
Await notice.
39, Ramesh P. Kulkarni,
Await. Await.
Await, my lord,
Await.
now we have not received.
40,
Await notice.
40, Madhukar and Deshpande,
For the appellant, my lord.
My lords, wait.
We'll verify that with the department, my lord.
On receipt of report. Await. Yes.
Stephen J. Niralki,
Your lordship, I am appearing on behalf of the appellant.
Await notice.
Much obliged.
Please look into. all
Yes,
these
my lord,
matters.
I'll all.
Yes.
My lord, 42, my lord, I pray for 2 weeks' time, my lord. As we had furnished the address of Uttar Pradesh, my lord. This Okay, it has come back as not sufficient. I'll verify the new address.
Of respondent number 1 and pay PF for issuance of notice. List down. Next.
43, VJ Nanjundaradya. Appellant.
What happened to the?
Okay, I'll verify, my lord. They have not yet given the report.
Then at HCCP and raise the time to verify and make a submission on the execution of NBW against respondent, issued against respondent. Yes.
44, Jaisimha KP.
Non-receipt.
Not yet received, my lord.
Await.
45, government advocate.
We have not yet received the report, my lord. I'll furnish the report.
In all these cases, you
All-
have to verify.
I will follow it up with my lord.
Yes. 46, await.
47, Bharat K.
For the petitioner, my lord,
Yes,
we have fulfilled the office compliance and there's that.
you have paid.
Yeah, we have paid.
Counsel for the appellant submits that has paid the PF for issuance of notice to respond. Issue notice to respond. Next.
These two, serial number 1, P. Prakash.
I appear for respondent.
Here. Yes. Please for the appellant.
Sorry, my lord, I represent the petitioner. In this case, my lord, I have addressed a letter to the party and the RPD cover has returned unserved, my lord.
Produce it with a.
Yes, I'm filing a memo along with that.
Pass over.
I'm filing a memo along with that. my lord.
You are filing now?
Yes.
Good. Current counsel for the appellant filed the memo. Reporting that even though he has addressed a letter. You have addressed a letter to the appellant or his legal representatives?
Appellant, my lord, appellant, because we don't know, my lord, who are the legal heirs. Because he was the only person who was coming to our office.
Addressed to the appellant. Which is returned unserved, as no such person in the said address. Then the counsel submits that even though the appellant is dead, he does not have any instructions about the legal representatives. Even the memo in the submission is placed on record, appeal is dismissed as abated.
Serial number 2, M.I. Srinivasan.
My lord, NBW has not been executed, my lord. We'll file the report, my lord. A week's time may be granted, my lord.
Non-receipt of await.
Serial number 3, P.B. Umesh.
For the appellant, my lord, 1 month time may be granted, my lord, because respondent is from the African country, my lord. That is the reason, my lord, we are
Please for a month's time to furnish correct address of the respondent who stays abroad after 4 weeks. List after 4 weeks.
Serial number 4, government advocate.
That my submission is that, my lord, we have prayed in our prayer column, my lord. There is no need of filing an application, my lord.
It is noticed that the appellant is the government represented by SPP. As seeking the leave of the court to prosecute is not necessary, hence list the matter. Admission.
For admission.
Call for trial court first. Next.
Serial number 5, Chetan Desai, Venkatesh Murthy.
I appear for
Petitioner
the
in this case, my lord.
respondent. Lordship may kindly have it on Thursday, my lord. I'll file my affidavit.
Counsel for the respondent, prays for time.
Please.
The complaint-
Kindly extend,
Thursday, my lord.
Statement of objection.
kindly extend the interim order, my lord.
interim order iddre extend ಮಾಡಿ list on, yes.
Hearing on IA, serial number 6. Chandrasekhar Reddy.
Appellant, my lord. The LR application is allowed on 19/7/24, my lord.
Allowed,
LR application is allowed on 19/7/24. As far as other two applications, my lord, they will not survive. They may be rejected as not present.
how could that application was allowed?
Inadvertence, my lord, these applications have been filed. Setting aside abatement and condonation of delay is not provided under criminal law.
What do you-
On that ground, application on 19/7/24, LR application is allowed.
Learned covered. Learned counsel for the appellant submits that today order dated 19/7/2024. The application to bring the legal representatives of the deceased appellant.
Madam,
Legal representatives of deceased appellant
yes, ma'am.
are already allowed. IA 1 of 2024. IA 1 of 2024. To bring the legal representatives of deceased appellant is already allowed, and therefore IA 1 and 2 of 2024 does not survive for consideration. Here is the order dated 19/7/2024. Since IA 1 of 2024 is allowed, IA 1,
Regarding amended appeal memo, I will file today itself, madam.
since the application to bring the legal representatives on record is already allowed, IA 1 of 2024 and 2 of 2024 filed for seeking condonation of delay by setting aside the abatement is dismissed as not pressed. Amended appeal memo.
Yeah, today I will file, madam. Today itself I will file.
File it, pass over. Not pressed on the phone, only accordingly not pressed on the matter first. Pass over.
Serial number 7, Nagesh. Backup procedure.
Appellant, my lords. My lords. Regarding serial, IA number, IA number 1 of 17, praise time, my lord, 1 week time, my lord. And regarding IA number 1 of 23, we have applied this one not press, my lord. And IA number 24 is allowed, my lord. And we have filed the death certificate also, my lord.
What is that?
IA number 24, my lord. 1 of 24.
1 of 24,
I have filed the death certificate, my lord. And that is allowed also, my lord.
when?
My lords, on 24th April, my lord.
Hmm?
24th April. I have filed the death certificate, my lord.
No, when the order was passed, sir. When that application was allowed?
Application was around 21/6, my lord.
Huh?
21/6.
No such order is there. You have not pressed IA 1 of 2023.
Yes, my lord. And
therefore-
IA number 1 of 24, that is allowed, my lord.
No. No such order. Pass over. Show me the order.
Okay.
Pass over.
Serial number 8, HS Santosh, Bhatshankar Shiram.
Counsel for the appellant is absent, no representation. IA 1 of 2024 is filed, seeking permission to produce additional documents. The same is ordered to be considered along with main matter. List for permission of, list for final reading. Next.
Serial number 9, Government Advocate. 153.
My lord, there is a delay of 153 days, my lord.
Third learned LCGP in IA 1 of 2009. There is delay of 153 days in preferring the appeal for the reasons stated in the affidavit accompanying any of the IA 1 of 2019 is allowed. Delay of 153 days is condoned. Call for trial court, ಬಂದಿದೆ, trial court records ಬಂದಿದೆ, list for admission. ಇರ್ಲಿ, admission.
K. Prasanna Shetty.
Lordship, for the appellant, there is a delay of 2 for 10 days, my lord.
Convince me about the admission.
The Lordship,
Regarding admission, you convince the court.
please.
IA 1 of 2020 is filed seeking condonation of delay of 214 days in preferring the appeal. Since there is inordinate delay, same is order to be considered along with merits of the case. Hence, call for trial court reports and list for admission. List for admission.
Please, ma'am.
7. Sarpati. Sampath A. Abdullah.
Idu same.
923 days delay.
So, admission.
12. Vishnu Egde.
Pass over.
13. Gopal Goda.
For appellant in this case, your lordship. 138 offense, your lordship. There is a delay
Counsel for the appellant.
88 days in
IA
filing the appeal.
1
That is due to the death of the mother of the appellant.
filed for seeking condonation of delay of 88 days. IA 2 of 2020 seeking leave of the court to prefer and to prosecute the appeal for the reasons stated in so and so. IA 1 and 2 of 2020 are allowed. Delay of 88 days condoned. Leave granted to prosecute.
14. K.
Call for
Prasanna
trial court
Shetty.
records, list for admission.
14.
Apology, my lord. Serial number 12, my lord.
Pass over.
I am ready.
No done. Yes.
14.
14.
For the appellants, there is a delay of 399 days.
Not in delay, 399 days delay along with merits. Court records, list for admission.
Please.
15. K. Rajgopal.
For the appellant, my lord, 138 case, it has been dismissed.
Mm.
The complainant could not go to the court because he is 75-year-old and he has underwent so many surgeries and all these things, my lord. So he couldn't go and there is a delay, my lord. In that matter, it has been dismissed for non-prosecution.
ಇಲ್ಲಿ 75 days ಅಂತೀರಿ, ಕಾಸ್ಟ್ ಟೈಟಲ್ 68 days, 68 years ಅಂತೀರಿ. As per the cost title, he is 68 years old.
Yes, ma'am.
In the application, you say, in the affidavit, you say you are 75 years.
He's 75 years old, my lord.
Look at the cost title, sir. What is the age?
70 years, my lord.
Huh?
70 years it has been written as
ನೋಡಿ.
70 years. Has been written as
ಒಂದೊಂದ್ ಕಡೆ ಒಂದೊಂದ್ ತರ ಬರೆಯೋದಾ? Here it is 68 years. In your copy, 70 years. In the affidavit, 75 years. Pass over.
Number 16. H.K. Onegoda. Special member.
Third, counsel to the appellant on a year 2024, seeking leave of the court to prosecute the appeal for the reasons stated in so and so. IA 1 of 2024 is allowed. Leave is granted to prosecute. Call for trial court records. List for admission. List for admission.
M.R. Balakrishna.
Same.
Time for the appellant in this matter, my lord.
Yes.
Is the appeal preferred by the defect?
Is allowed.
Yes.
List for admission. Next.
For further argument, serial number 18, M.J. Alva.
A notice may be issued to the respondents, number 2 and 3.
Convince me about admission.
Kumar R.S. Gowda.
Hey, my prepare. Respondent, you are. Brother, kindly see, my lord.
The appellant has challenged the lower apex court order acquitted by the accused.
Yes.
Honorable court has given the several suitable reason. See petition, para 4, facts of the case. Number 1, the appellant and the respondent are the known to each other since long time, having friendly relationship between them. Your Honor, my lord, in this complaint, issue the legal notice. You given the evidence in some way of this own statement. Complaint, original complaint, my lord. Para 3, the complaint submit that the complainant and accused are known to each other for the last 1 year. In the complaint, Your Honor. Issue the legal notice to the respondent on 26/9/2016.
You admit issuance of check.
No, Your Honor. Only you admittedly only date and amount, Your Honor. ನಾನು ಬರ್ಕೊಟ್ಟಿದ್ದು ಏನಂದ್ರೆ ವೆಂಕೋಪರಾವ್ ಅವರಿಗೆ ಅವ್ರ ಅಣ್ಣಂಗ್ ಬರ್ಕೊಟ್ಟಿದ್ದು.
Check belongs to you.
Yes. I issued my account.
It bears your signature.
Yes, Your Honor.
Then the presumption under 139 will arise.
Your Honor, kindly see if fraudulently
That is your defense.
Yes, Your Honor.
Yes.
The respondent not issue the after pay the amount to the is Venkovarao, not issue the notice to return the check and not lodge the complaint against the before the honorable police station. Only 2 mistake. You misuse the check. The respondent asked the advocate. The advocate has contested seriously this case. So issues is enough ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹಾಗಾಗಿ only Your Honor, only do 2 mistake. You misuse the check. Collide with the Venkobarao. ಹಾಗಾಗಿ ನಾನು ಅದರಲ್ಲಿ Your Honor, is no relationship, is no transaction between the appellant and respondent. ಅದಕ್ಕೆ ಸಮಯ ನಾನು ಲೀಗಲ್ ನೋಟಿಸು, ಕಂಪ್ಲೇಂಟು, ಅವ್ರು ಕೊಟ್ಟಿರುವಂತ ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟು ಮತ್ತು ಇಲ್ಲಿ ಹಾಕಿರುವಂತ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಫ್ರೆಂಡ್ಲಿ ಲಾಂಗ್ ಟೈಮ್ ಅಂತ ಹೇಳಿದರೆ ಅಲ್ಲಿ 1 year ಅಂತ ಹೇಳಿದ್ದಾರೆ. 1 Your Honor.
What is your defense? The check was issued to Venkobarao.
Yes, Your Honor, sir. I have obtained the loan from the Venkobarao, the appellant brother.
Is there any cross-examination?
Yes, Your Honor, ಬರ್ತೀನಿ ಸರ್ 2 ನಿಮಿಷ.
ಬಂದ್ಬಿಡಿ ಅಲ್ಲಿಗೆ.
ಈ ಕ್ರಾಸ್ ಆಫ್ PW1
Yes.
21/2/2017 2/1/2017 ಪ್ಯಾರಾ 2 ಸ್ವಾಮಿ. ಆರೋಪಿ ತಮ್ಮ ಮತ್ತು ನಾನು ಒಂದೇ ಕಡೆ ಡ್ರೈವರ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಕಾರಣ ಆರೋಪಿಯ ಪರಿಚಯ ಆಗಿರುತ್ತದೆ. ಆರೋಪಿಯ ತಮ್ಮ 5 ವರ್ಷಗಳಿಂದ ಪರಿಚಯ.
ಸರ್, ನಾನು ಕೇಳ್ತಾ ಇರೋದೇನೋ, ನೀವು ಹೇಳ್ತಾ ಇರೋದೇನೋ.
ಅಲ್ಲ.
Is there any cross-examination to PW1 regarding your defense that you had issued the check in question, not to the complainant, but to
Yes.
his brother Venkobarao?
Yes, Your Honor.
Is there any cross-examination?
ಅದರಲ್ಲಿ ಇವರ ಹೇಗೆ
Is there any suggestion at least?
ಸಜೆಷನ್
I could not find it. Even the respondent could not find that.
ಪ್ಯಾರ 15 ಕ್ರಾಸ್ ಆಫ್ PW1 14/3/2017 ನಾನು ಮತ್ತು ನನ್ನ ಅಣ್ಣ ವೆಂಕೋಬರಾವ್ ಅನ್ಯೂನ್ಯವಾಗಿದ್ದೇನೆ ಆಗಿದ್ದೇವೆ. ಆರೋಪಿ ಮತ್ತು ನನ್ನ ಅಣ್ಣ ವೆಂಕೋಬರಾವ್ ಅವರು ಬಹಳ ವರ್ಷಗಳಿಂದ ಪರಿಚಯಿಸಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನನ್ನ ಅಣ್ಣ ವೆಂಕೋಬರಾವ್ ರವರಿಂದ ಮನೆ ಕಟ್ಟುವ ಸಲುವಾಗಿ 9,50,000 ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಹಣದ ಭದ್ರತೆಗಾಗಿ ಪೇಜ್ 15 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ PW1 14/3/2017 my lord. ಪ್ಯಾರಾ 6 and 7 ಆರೋಪಿ ನನ್ನ ಅಣ್ಣ ವೆಂಕೋಬರಾವ್ ಅವರಿಂದ ಮನೆ ಕಟ್ಟುವ ಸಲುವಾಗಿ 9,50,000 ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಹಣದ ಭದ್ರತೆಗಾಗಿ ನನ್ನ ಅಣ್ಣ ನೀಪಿ 1 ಚೆಕ್ ಅನ್ನು ಆರೋಪಿಯ ಕಡೆಯಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಚೆಕ್ನಲ್ಲಿ ಹಣ ಮತ್ತು ದಿನಾಂಕ ಮಾತ್ರ ನಮೂದಿಸಿ ಹೆಸರು ಖಾಲಿ ಬಿಟ್ಟಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. 8/7/2016 ಆರೋಪಿ ನನ್ನ ಅಣ್ಣನಿಗೆ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಹೈದರಾಬಾದ್ ಬ್ಯಾಂಕ್ ಡಬಲ್ ರೋಡ್ ಬ್ಯಾಂಕಿನಲ್ಲಿ 9,50,000 ಹಣ ಡ್ರಾ ಮಾಡಿ ಬ್ಯಾಂಕ್ ಆವರಣದಲ್ಲಿಯೇ ನನ್ನ ಅಣ್ಣನಿಗೆ ಹಣ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಹೈದರಾಬಾದ್ ಬ್ಯಾಂಕ್ JC ರೋಡ್ ಒಂದು ಹೇಳಿರುತ್ತಾರೆ ಬ್ಯಾಂಕ್ ವಿಳಾಸ. ನಾವು ಡಬಲ್ ರೋಡ್ ಅಂತ ಹೇಳ್ತೀವಿ ಸ್ವಾಮಿ, ಬಟ್ ಅವರು ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಹೇಳ್ತಾರೆ. JC ರೋಡ್ ಅಲ್ಲಿ ಡ್ರಾ ಮಾಡಿಕೊಟ್ಟಿರೋದು. I given them my defense evidence.
You plead discharge.
Yes, Your Honor.
Have you produced any document to that effect?
Your Honor, kindly see in the Honorable Lower Court, I filed the one application, production of the CD, conversation of the Venkobarov and respondent. One, Your Honor. Another one is in bank premises having the CCTV camera. So direction to bank authority produce this.
Why all those?
ನಾನು CD ಹಾಕಿದ್ದೀನಿ ಇದರಲ್ಲಿ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾನು CD ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
It is your contention that you have withdrawn rupees 9,50,000.
Yes, Your Honor. My lord, document number 9 D3, Your Honor. My side mark the document. 7/7/2016. I having the 10,000 rupees my account, Your Honor. D3, my lord.
D3 is this statement.
My statement. 7/7/2016, 10,000 rupees. ನಾನು ಅವ್ರಿಗೆ 8/7/2016 I draw the amount. ವೆಂಕೋಬಿರಾವ್ಗೆ. ಇನ್ ಬಿಟ್ವೀನ್ Your Honor, ಅಲ್ಲಿ ಒಂದು ಪಾಯಿಂಟ್ ಇದೆ ಸ್ವಾಮಿ. 4/5/7/2016 ಆ ಮೇಲಿದೆ ಸ್ವಾಮಿ. ಮೂರನೇ ನಮೂದು ರೆಫರೆನ್ಸು 5/7/2016 ಡಿಸಾನರ್ ಆಫ್ ಚೆಕ್. ದಿಸ್ ಪ್ರೆಸೆಂಟ್ ಚೆಕ್ ಇಸ್ ಡಿಸಾನರ್ಡ್. 100 ರೂಪಾಯಿ ಕಟ್ಟಾಗಿದೆ. ನನಗೆ ಯಾವಾಗ 100 ರೂಪಾಯಿ ಕಟ್ಟಾಯಿತು, ನಾನು ಅವ್ರ ಅಣ್ಣಂಗೆ ಫೋನ್ ಮಾಡಿ ನನಗೆ ಅಮೌಂಟ್ ಬರುತ್ತೆ 7ನೇ ತಾರೀಕೆ, ನಾನು ಹಣ ಬಂದ ತಕ್ಷಣ ಡ್ರಾ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂದ್ಬಿಟ್ಟು ನಾನು 8ನೇ ತಾರೀಕೆ ನಾನು ಡ್ರಾ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ. ನಾನು ಮೈ ಲಾರ್ಡ್ ಅಪಲೆಂಟ್ ಹಾಕವ್ರೆ ಅಂತ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ವೆಂಕೋಬರಾವೇ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಅಂದಾಗ ನಾನು ಅಮೌಂಟ್ ಡ್ರಾ ಮಾಡಿ ಪೇ ದಿ ಅಮೌಂಟ್. ಅವರು ಅದರಲ್ಲಿ ಕಾನ್ವರ್ಸೇಷನ್ ಅಲ್ಲಿ ಮಾತಾಡಿದ್ದಾರೆ. ನಾನು CD ಆಗಿ ನಾನು ಅವ್ರು ಏನ್ ಮಾತಾಡಿದ್ದೀನಿ ಆ ಕಾನ್ವರ್ಸೇಷನ್ ಒಂದು ಅಲೋ ಮಾಡಿದ್ರೆ Your Honor, ಕೇಸ್ ಇವತ್ತು ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲೇನೆ ಅಕ್ವಿಟ್ ಆಯ್ತಿತ್ತು. is simply blindly rejected.
But why you are saying that you do not know who is Venkobarov?
Your Honor, my lord, ನಾನು ಅಕ್ಯೂಸ್ಡ್ ಅಪಲೆಂಟ್ ಅವ್ರನ್ನ ನಾನು ಸಜೆಸ್ಟ್ ಮಾಡ್ತೀನಿ ಇದರಲ್ಲಿ ವೆಂಕೋಬರ್ ಅವ್ರನ್ನ ನೀವು ಸಾಕ್ಷಿ ಮಾಡಿಕ್ ಆಗುತ್ತಾ ಅಂತ. ಆಗಲ್ಲ ಅಂತಾರ ಅವರು.
When you are examined as DW1.
ಬಟ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಮಾಡಿಲ್ಲ ಅಲ್ಲ, you say I don't know who is Venkobarov.
ಇಲ್ಲ, ಅಲ್ಲಿ ಒಂದು Your Honor kindly see ಆ ಲೈನ್ಗಳು ಒಂದು ಸ್ವಲ್ಪ ನಾನು ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಪೇಜ್ 3, 9/6/2017. ದೂರುದಾರರು ನನಗೆ 5 ವರ್ಷಗಳಿಂದ ಗೊತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಮ್ಮ ಚಾಲಕನ ಕೆಲಸ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. ದೂರುದಾರರು ಮತ್ತು ನನ್ನ ತಮ್ಮ ಒಂದೇ ಕಡೆ ಕೆಲಸ ಮಾಡುತ್ತಾರೆ ಮತ್ತು ಸ್ನೇಹಿತರು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ದೂರುದಾರರ ಅಣ್ಣ ವೆಂಕೋಬರಾವ್ ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ದೂರುದಾರರು ಅವರ ಜೊತೆ ಬರುತ್ತಿರುತ್ತಾರೆ. ದೂರುದಾರರು ವೆಂಕೋಬರಾವ್ ಅವರ ತಮ್ಮನಾದ ಕಾರಣ ನನಗೆ ಅವರು ಸಹ ಗೊತ್ತು ಎಂದರೆ ಸಾಕ್ಷಿ ಈ ವಿಚಾರ ನನಗೆ ಚೆಕ್ ಅನ್ನು ಹಾಜರು ಮಾಡಿದಾಗ ವೆಂಕೋಬ ನನಗೆ ಕರೆ ಮಾಡಿದಾಗ ಗೊತ್ತಾಗಿರ್ತದೆ. ಅದು ಫುಲ್ ಲೈನ್ ಓದ್ಬೇಕು ಸ್ವಾಮಿ. ಅದು ಯಾಕಂದ್ರೆ ಒಂದು ಲೈನ್ ಅಲ್ಲಿ ಅದು ನೆಗೆಟಿವ್ ಬರೋದು. ಅದು
ಫುಲ್ ಲೈನ್ ಓದಿದ್ಮೇಲೆ what is the meaning of that sentence?
ಅಲ್ಲಿ
when the check was presented for encashment, you came to know about Venkobarov.
ಅಲ್ಲ, ಅವ್ರು ಚೆಕ್ ಮಾಡ್ಲಿಲ್ಲ ಸರ್. ಚೆಕ್ ಪ್ರೆಸೆಂಟೇ ಮಾಡಿಸ್ಲಿಲ್ಲ ನಾವು ಆ ಚೆಕ್ ನ.
What is the meaning?
ಅಲ್ಲ, ಅವ್ರು ಅಮೌಂಟ್ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅಂದಾಗ ನಾನು ಏನು ಅಮೌಂಟ್ ಬಂತು ಡ್ರಾ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ. ಅವ್ರೇನ್ ಹೇಳಿದ್ರು ನಾನು ಚೆಕ್ ನಾನು ಕೊಡ್ತೀನಿ ಅಂತ ಹೋದಂತವ್ರು.
The meaning of the sentences just now you read it.
ಆಯ್ತು ಸರ್. ಇಲ್ಲ, ದೂರುದಾರನ ವೆಂಕೋಬರಾವ್ ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ದೂರುದಾರರು ಅವರ ಜೊತೆ ಬರುತ್ತಿರ್ತಾರೆ ಅಂದ್ರೆ ವೆಂಕೋಬ ಜೊತೆ ಬಂದಿರ್ತಾರೆ ಸಭೆ. ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲ್ಲ ಹೆಸರು. ದೂರುದಾರರು ವೆಂಕೋಬರಾವ್ ಅವರ ತಮ್ಮನಾದ ಕಾರಣ ನನಗೂ ಅವರು ಸಹ ಗೊತ್ತು ಎಂದರೆ ಸಾಕ್ಷಿ ಈ ವಿಚಾರ ನನಗೆ ಚೆಕ್ ಅನ್ನು ಹಾಜರು ಮಾಡಿದಾಗ ವೆಂಕೋಬ ನನಗೆ ಕರೆ ಮಾಡಿದಾಗ ಗೊತ್ತಾಗಿರುತ್ತದೆ ಅಂತ. ಅಂದ್ರೆ ಅವರು ಗೌರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರ ತಮ್ಮನ ಕೈಯಲ್ಲಿ ನಾನು ಚೆಕ್ ಅನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಸಿದೀನಿ ಅಂತ ಹೇಳಿರ್ತಾರೆ.
How long you know Venkobarao?
ವೆಂಕೋಬರಾವ್ ನನ್ನ ತಮ್ಮನ ಕಡೆಯಿಂದ ಪರಿಚಯ ಆಗಿರುತ್ತೆ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಅಟ್ ಆಲ್. ಅವರು ವೆಂಕೋಬರಾವ್ ಮಾತ್ರ ನಂಗೆ ಗೊತ್ತಿದ್ದು. ಇವರು ನನಗೆ
ಎಲ್ಲಿ ಹೇಳಿದಿರಿ? ಫಸ್ಟ್ ವರ್ಡೇ Venkobarao
given the your honor, my lord, our defense of my evidence, I given the detail of my defense. My defense, sir. My defense statement ಅಲ್ಲಿ ಫುಲ್ಲು ಚೆಕ್ ಹೆಂಗೆ ಅವ್ರಿಗೆ ಹೋಗ್ತೋ ನಾನೇನು ಇದ್ ಮಾಡಿದ್ದೀನಿ ಎಲ್ಲ ಇದೆ ಎಲ್ಲ. My evidence DW1, my lord, para 2. I state that the averment made in the complaint that I had approached the complaint for financial assistance to 22,50,000 for the purpose of the construction of the house situated at Kamlanagara, Bangalore, agreeing to repay the same as early as possible, and the complaint has paid a sum of rupees 22,50,000 rupees on different dates situated in complaint is hereby denied as false. It is submitted that complaint is stranger and there is no friendship between me and complaint. This third paragraph. I state that the complaint brother one Shri Venkobarao, who came to know through my brother Shri Chandrasekhar during the month of December 2015, I had approached him for hand loan 9,50,000 rupees and agreed to repay the same within the 6 months. And I further submit that at the time of receiving the loan amount, the complaint brother Shri Venkobarao had instit one blank post-dated check towards the security for the repayment of the loan amount, and accordingly, I had issued a check bearing number 925099 dated 4/7/2016 for 9,50,000 rupees without mentioning the name payee, and said Venkobarao assured that I will return the said check after repayment of the said loan amount. I further state that during this last week of June 2016, Shri Venkobarao insisted for repayment of the said loan amount, and assured that I had applied for loan from Canfin Bank. Same is going to be sanctioned within the 1 week, and assured him to repay the same within the 1 week. But Shri Venkobarao, without informing me, he has misused the check for the security purpose of loan and presented the same through his brother. I found complaint on 4/7/2016. ಅದು ನನ್ನ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ನನಗೆ ಮೆಸೇಜ್ ಬಂದಾಗಲೇ ನಾನು ಅವ್ರನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ದು. I further state that the said check which was presented on 4/7/2016 was got bounced since there was a delay in sanction of loan amount. Immediately, Shri Venkobarao had informed that.
You initiated any action against Venkobarao?
No, my lord.
Then,
Till today is no.
and you have not claimed the
Hello.
legal notice?
No, madam.
You have not given any reply?
No.
Then is it not fatal to your case?
What
You admit your signature, you. admit your
silently
check.
that to two legal action,
Yes,
you misuse the check, and till today is present the case.
see, the only defense taken by you is misuser of the check
Yes.
given to Venkobarao. How you have proved it?
My lord, one.
The burden is on the accused
Yes,
to
yes.
probabilize the defense.
ಅಲ್ಲ ಅವರು ನನಗೆ ಇಸ್ ನಾಟ್ ಪೇಡ್ ದಿ ಎನಿ ಪೇಮೆಂಟ್. ಮೈ ಲಾರ್ಡ್, ಅವ್ರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ ಅನೆಕ್ಷರ್.
Sir, please understand the
ಇಲ್ಲ,
position
ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಈ
of law is that
ನೋ
position-
ಬಿಟ್ವೀನ್, ಮೈ ಲಾರ್ಡ್, ನೋ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಬಿಟ್ವೀನ್ ದಿ ಅಪಲೆಂಟ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
maybe.
ಈ ಹ್ಯಾವಿಂಗ್ ದಿ ಅಕೌಂಟ್ ಅಮೌಂಟ್ ಇನ್ ಓನ್ಲಿ ಇನ್ ಅಕೌಂಟ್, ಅದರಲ್ಲಿ ಏನು ಅವ್ರು ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಎರಡೇ 5 minutes ಇದೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ಬಿಟ್ಟು ನಾನು ಹೇಳ್ತೀನಿ ಸರ್. ಏನಕ್ಕೆ ಅಂದ್ರೆ ಅವ್ರ ಅಕೌಂಟ್ ಡ್ರಾ ಮಾಡಿ ತಿರ್ಗಾ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅವ್ರ ಅಕೌಂಟ್ ಅಲ್ಲೇ ಇದೆ. ಇಟ್ಸ್ ನೋ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ನನಗೆ ಲೀಗಲಿ ನನಗೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿಲ್ಲ, ಹಂಗಾಗಿ ನೋ ರಿಲೇಶನ್ಶಿಪ್. ನಾನು ಯಾವುದೇ ಅಮೌಂಟ್ ಕೊಡಿಗೆ ಒಂದು ಲಯಬಿಲಿಟಿನೇ ಇಲ್ಲ. ಒಂದೇ ಒಂದು ಸರ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 8 ಮೈಲ್ 8 and 9 8 ಮೈ ಲಾರ್ಡ್ 10 lakhs 16 ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. 50,000 rupees 11/4/2016 ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ. 5 lakhs ಮಾಡಿದೆ. 2 lakhs in this legal notice, complaint, sworn statement. Cross ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ನನ್ನ ವೈಫ್ ಎಕ್ಸಿಬಿಟ್ P9 ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅದರಲ್ಲಿ ನನ್ನ ವೈಫ್ ಅಲ್ಲಿ ಡ್ರಾ ಮಾಡಿ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ. ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಎಲ್ಲೂ ಸಾಕ್ಷಿ ಇಲ್ಲ, ಯಾವುದೇ ಐ ವಿಟ್ನೆಸ್ ಇಲ್ಲ, ಯಾರನ್ನೂ ಮಾಡಿಲ್ಲ. ಐದರ್ ಅಪಲೆಂಟ್, ಐದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಅವ್ರ ವೈಫು ಎಲ್ಲರೂ ಇದ್ರು ಅಂತಾರೆ. ಯಾವುದೇ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ. ವೆಂಕೋಬರಾವ್
Know the position of law.
Yes, my lord.
When you admit that you have issued the check with your signature, the presumption under 139 will arise. The burden is on you to rebut the presumption. Burden is not on the complainant once you admit issuance of the check. That is the position of law. So there is no point in submitting that the complainant has not proved lending. First you rebut the presumption. Thereafter the burden shifts on the complainant.
But
The position of law, very settled position of law.
but misuse the check, my lord.
How you probabilized it?
But
Was the specific defense taken by you? You probabilized it.
I have given my defense evidence, my lord.
Have you examined Venkobarao?
ವೆಂಕೋಬರಾವ್ ನಾವು ಮಾಡ್ಲಿಲ್ಲ. ಅವ್ರಿಗೆ ನಾನು
ಮಾಡಲ್ಲ.
ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ.
Burden is on you. You have taken the defense.
But in the both are in conversation of the phone call, I produce the lower court. Lower court is not allow the IA. So this is a good evidence, my lord. ಅದರಲ್ಲಿ my lord, exhibit P8 ಪ್ರಕಾರ ಅಮೌಂಟ್ ಡ್ರಾ ಮಾಡೋರೆ, ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಯಾವುದೇ ಸಿಂಗಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಆಮೇಲೆ ಅವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನಾನು ಆಮೇಲೆ 20,50,000 rupees ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾರೆ. 9,50,000 ಮಾಡ್ತಾವ್ರೆ.
I can't help, sir. I can understand the respondent arguing in this fashion. He is a layman. He may not know the niceties of the position of law. But you being the advocate should understand. Repeatedly, I am saying you what is the position of law. The burden is on you to probabilize your defense. Unless you probabilize your defense, the burden will not shift on the complainant.
Instead of hearing produce several authorities support to my the position of law next week.
Illa, I am going to dispose of today.
I produce several authorities. The contention of my defense.
Bring up on page para number.
Para 13 million. Para 13 million.
Para
13.
of Baslingappa.
Yes. ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ನಮ್ಮ ನ್ಯಾಯಾಡಳಿತ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಯಾವಾಗಲೂ ದೃಷ್ಟಿಯಲ್ಲಿ ಇರಿಸಬೇಕಾದ ಒಂದು ಪ್ರಧಾನ ತತ್ವವೇನೆಂದರೆ ಆರೋಪಿಯು ಆತನ ಮೇಲೆ ಹೊರಿಸಲಾದ ಅಪರಾಧಿ ಎಂದು ತೋರಿಸಬಹುದಾದ ಸಾಕ್ಷ್ಯವನ್ನು ಹಾಜರುಪಡಿಸುವ ಮೂಲಕ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಪೂರ್ವಭಾವನೆಯನ್ನು ಖಂಡಿಸಿದ ಹೊರತು ಆರೋಪಿ ಎಂದು ದೋಷಾರೋಪಣೆಗೊಳಗಾದ ವ್ಯಕ್ತಿಯು ಮುಗ್ಧನೆಂಬುದಾಗಿಯೇ ಪೂರ್ವಭಾವನೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಆರೋಪಿಯು ಅಪರಾಧವನ್ನು ಸಾಬೀತುಪಡಿಸುವ ಹೊಣೆಯು ಪ್ರಾಸಿಕ್ಯೂಷನ್ದಾಗಿರುತ್ತದೆ. ಅನ್ಯಥಾ ಆ ಹೊಣೆಯನ್ನು ಅದು ಸ್ವತಃ ಬಹಿರಂಗಪಡಿಸಿದ ಹೊರತು ಆರೋಪಿಯು ಅಪರಾಧ ನಿರ್ಣಯವನ್ನು ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ದಾಖಲಿಸಲಾಗುವುದಿಲ್ಲ. ಆರೋಪಿಯು ಅಪರಾಧಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಾಸನಾತ್ಮಕ ಪೂರ್ವಭಾವನೆಗಳು ಉದ್ಭವಿಸಿದ ಕೆಲವು ಮೊಕದ್ದಮೆಗಳಲ್ಲಿ ಇವೆಯಾದರೂ ಆ ಮೊಕದ್ದಮೆಗಳಲ್ಲೂ ಸಹ ಪೂರ್ವಭಾವನೆಯನ್ನು ಇತ್ಯರ್ಥ ಮಾಡುವುದಕ್ಕೆ ಮುಂಚೆ ಇರುವ ಸಂಗತಿಗಳ ಇರುವಿಕೆಯನ್ನು ಸಾಬೀತುಪಡಿಸುವ ಹೊಣೆಯು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಲಿದೆ. ಆ ಸಂಗತಿಗಳು ಇರುವುದನ್ನು ಒಮ್ಮೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ತೋರಿಸಿದಲ್ಲಿ ನ್ಯಾಯಾಲಯವು ಶಾಸನಾತ್ಮಕ ಪೂರ್ವಭಾವನೆಗಳನ್ನು ಎತ್ತಬಹುದು ಮತ್ತು ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಪೂರ್ವಭಾವನೆಯನ್ನು ಖಂಡಿಸುವ ಕೆಲವು ಆರೋಪಿಯದ್ದಾಗಿರುತ್ತದೆ. ಅಂತಹ ಮೊಕದ್ದಮೆಗಳಲ್ಲಿಯೂ ಸಹ ಆರೋಪಿಯ ಮೇಲಿರುವ ಹೊಣೆಯು ಸಾಮಾನ್ಯವಾಗಿ ಆರೋಪಿಯ ಅಪರಾಧವನ್ನು ಸಾಬೀತುಪಡಿಸುವ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಲಿರುವ ಹೊಣೆಯಷ್ಟು ಭಾರವಾಗಿರುವುದಿಲ್ಲ. ಯುಕ್ತವಾಗಿ ಸತ್ಯವಾಗಿರಬಹುದಾದ ಆರೋಪಿಯ ಮುಗ್ಧತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆಯನ್ನು ಕುರಿತು ಕೆಲವು ಸಾಕ್ಷ್ಯವನ್ನು ತಂದಿದ್ದರೂ ಆಗಲೂ ಸಹ ಅದನ್ನು ಸತ್ಯವೆಂದು ಸಕಾರಾತ್ಮಕವಾಗಿ ಸಾಬೀತು ಮಾಡಲಾಗುವುದಿಲ್ಲ. ಆಗ ಆರೋಪಿಯು ಖುಲಾಸೆಗೊಳಿಸುವುದಕ್ಕೆ ಹಕ್ಕುಳ್ಳವನಾಗಿರುತ್ತಾನೆ.
ಎಲ್ಲಿ ಇದೆ ಅಥೆಂಟಿಕ್ ಕಾಪಿ ಅಲ್ಲ ಇದೇನು ಟೈಪ್ ಕಾಪಿ ತಗೊಂಬಂದಿದ್ದೀರಲ್ಲ
ಅದು ಪ್ರಿಂಟ್ಔಟ್ ತೆಗ್ದಿರೋದು ಮೇಲೆ.
ಪ್ರಿಂಟ್ ಔಟ್ ಇದೆ ಹೇಗೆ?
ನೆಕ್ಸ್ಟ್ 31ನೇ ಪೇಜ್.
1 minute sir.
ಪೇಜ್ 27.
Wait for some, one minute. Read para 24. The very same bustling appa. Para 24, read it. Please read it.
Applying the present preposition of law as noted above, in fact of the present case, it is clear that signature on the check having been admitted, a presumption shall be raised under section 139 of that the check was issued in discharge of debtor liability. The question to be looked into is as to whether any probable defense was raised by the accused in cross-examination PW1 when the specific question was put that check was issued in the relation to the loan or arrest 25 lakhs taken by the accused. The PW1 said that he does not remember. PW1 is evidence admitted that the.
So that is all on facts of the case. But what is the position of law? Once you admit the check, issuance of check, the burden lies on the accused, Kodi.
But my lord, ಈಗೇನವರು exhibit 8 and 9 ಅನ್ನ ಹಾಕಿದ್ದಾರೆ. ಅವ್ರ ಅಕೌಂಟ್ ಯಾವ್ದು ಡ್ರಾ ಮಾಡಿರೋದ ಈ ಶೋ ದಟ್ ಇನ್ ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್ ಇನ್ ಪ್ಲೀಡೆಡ್ ಬಟ್ ನಾಟ್ ಪೇಡ್ ದಿ ಮೀ. ಅದರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್
ನೆಕ್ಸ್ಟ್ ಯಾವುದು?
ಪ್ಯಾರಾ 28 ಪೇಜ್ 27 ಪ್ಯಾರಾ 28 ಅಗತ್ಯ ಸಮರ್ಥನೆಗಳು ಇಲ್ಲದಿರುವಲ್ಲಿ ವಿಪರ್ಯಾಸ ಹೊಣೆ ಕಂಡಗಳು ಸಾಮಾನ್ಯವಾಗಿ ಸಾಕ್ಷ್ಯದ
facts of the case. Next.
ಪೇಜ್ 31 27ರಲ್ಲಿ ಸಾಮಾನ್ಯವಾಗಿ ವಾಣಿಜ್ಯ ವ್ಯವಹಾರಗಳಲ್ಲಿ ತೊಡಗಿರುವ ಖಾಸಗಿ ಪಕ್ಷಗಾರರಿಗೆ ಸೀಮಿತವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಅದನ್ನು ನಿಯಂತ್ರಣಾತ್ಮಕ ಅಪರಾಧವನ್ನಾಗಿ ವಿವರಿಸುವುದು ಉತ್ತಮ. ಅಂತ ಸನ್ನಿವೇಶಗಳಲ್ಲಿ ಪ್ರಮಾಣಾನುಸಾರ ಪರೀಕ್ಷೆಯು ಪ್ರತಿವಾದಿ ಆರೋಪಿ ಮೇಲಿನ ವಿಪರ್ಯಾಯ ಹೊಣೆಯ ಖಂಡಗಳ ರಚನೆಗೆ ಮತ್ತು ಅರ್ಥವಿವರಣೆಗೆ ಮಾರ್ಗದರ್ಶನವಾಗಿರಬೇಕು ಮತ್ತು ಪ್ರತಿವಾದಿ ಆರೋಪಿಯಿಂದ ಸೂಕ್ತವಲ್ಲದ ರೀತಿಯಲ್ಲಿ ಉನ್ನತ ಪ್ರಮಾಣದ ಪುರಾವೆಯನ್ನು ಒದಗಿಸುವುದನ್ನು ನಿರೀಕ್ಷಿಸಲಾಗದು.
Yes, next.
Next, Subramani versus Damodar Naidu. The finance and monetary laws, Negotiable Instrument Act 1881, 138, 118 and 139, dishonor of check, legally recoverable debt not proved as complaint could not prove sources of income from which alleged loan was made to appellant accused. The presumption of favor of the holder of check hence held stood reputed acquittal restored.
So on facts, the presumption was rebutted.
Yes, my lord.
I am asking you how you rebutted the presumption. I am not getting any answer.
Dattatreya versus Saranappa.
ಇದೇನಿದು ಅಶೋಕ್ and versus state of state. Why are you citing this?
My lord.
ಬೆಂಚ್ ಒಂದು ಡಿಸಿಷನ್ ಹಾಕಿದಿರಲ್ಲ, ವೈ?
Dattatreya versus.
ಅದಕ್ಕಿಂತ ಮೊದಲು ಒಂದು ಅಶೋಕ BH versus state. Why you relied on this?
ಇಲ್ಲ ಅದು 5 ವಿಷಯ. Next, Dattatreya versus Saranappa. Page. Point 31 ಆದ್ಮೇಲೆ ಸರ್ 20 ಪೇಜ್ ನಂಬರ್ 28 ಮೇಲೆ ಪ್ಯಾರ 31ರಲ್ಲಿ ನಂಬರ್ .1 ಇವರು criminal jurisprudence emphasis on the fundamental essence of liberty and presumption of the innocence unless proved guilty. This presumption got embroiled in the virtue of the concurrent findings of the acquittal. Therefore, this court must be extra exigent and while dealing with a challenge against acquittal, as said presumption gets reinforced by the virtue of the reasoned favorable outcome. Consequently, an onus of the prosecution side become more burdensome pursuant to the said doubtful presumption. In case of concurrent findings of acquittal, this court would ordinarily not interfere with such. We considering the principle of liberty enshrined in the Article 21 of Constitution of India 1950, unless privacy is blatantly forthcoming and there are complying reasons. ಮೂರನೇ point. Where two views are possible, then this court would not ordinarily interfere and reverse in concurrent findings of acquittal. However, which are the situation is such that only conclusion which could be arrived from a comprehensive appraisal of the evidence show that there has been a grave miscarriage of justice. Then, notwithstanding such concurrent view, this court would not restricted itself adopt on appointed we state of Uttar Pradesh and Tansi. Andhra 2023 to KLR 643 Jadis Reddy versus G. Chandrana. The para 14 mailer. No doubt the complaint is a holder of the check in due courses and the initial presumption is in his favor, but it is required to be noted here that he is a public servant and handling cash without presumption from the higher officer. Further, he financially capacity itself.
How it is applicable to you?
The Honorable Apex Court has no financial capacity of the
Whether the complainant is a public servant?
Is admitted in the cross examination, is a public servant of the servant, my lord. So 22 lakhs 50,000 rupees. Only you stating that in draw the amount and pay the respondent, my lord.
But
Is
he has
admitted.
produced the statement of account.
Having the document number 8 and exhibit P8, my lord. 8 ಅಲ್ಲಿ ಇದೆ. ಅವ್ರೇನು 22 ಲಕ್ಷ ಏನು ಡ್ರಾ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾರೆ, ಕೊಟ್ಟಿದ್ದಾರೆ ಬಟ್ ಡ್ರಾ ಮಾಡಿ ತಿರ್ಗಾ ಅವರೇ
ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ತಾನೆ,
ಡೆಪಾಸಿಟ್ ತಿರ್ಗಾ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಅಲ್ಲೇ ಆಮೇಲೆ ಇವರನ್ನ ಕೈಲಿಸಿ ಅವ್ರ ವೈಫ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಡ್ರಾ ಮಾಡಿದೆ ಅಂತ ಎಲ್ಲೂ ಹೇಳಲ್ಲ ಅವರು. ಈ ಲೋಗಲ್ ನೋಟಿಸ್ ನೋಡಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಆಮೇಲೆ ಇದು 5 ಲಕ್ಷ ಒಡವೆ ಮಾಡಿದೀನಿ ಅಂತಾರೆ. ಅದೇ ಡೇಟ್ ಅಲ್ಲಿ ಅವರ ಅಕೌಂಟ್ಗೆ 11 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಆಗುತ್ತೆ. ಒಡವೆ ಮಾಡಿರೋದಕ್ಕೆ ಸ್ಲಿಪ್ ಇಲ್ಲ. Absent of the receipt, my lord, you not paid the amount, having the account only draw. Thereafter, he deposited that exhibit D9 is itself showing itself disclose the real fact. The exhibit exhibit P8, my lord. ಅವರು 5/3/2016 ಅಲ್ಲ 16/3/2016 ಕ್ಯಾಶ್ ವಿತ್ಡ್ರಾ 9,99,000 ರೂಪಾಯಿ. ನಂತರ 11/4/2016 ಕ್ಯಾಶ್ ವಿತ್ಡ್ರಾ ಸೆಲ್ಫ್ 50,000. 13/4/2016 ಸೆಲ್ಫ್ 5 ಲಕ್ಷ. ನಂತರ 2 ಲಕ್ಷ ಮತ್ತು 5 ಲಕ್ಷದ್ದು ಎಲ್ಲೂ ಹೇಳಲ್ಲ. ಅವ್ರ ವೈಫ್ ಅಕೌಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ದಾರೆ ಎಕ್ಸಿಬಿಟ್ P9 ಮೈಲಾಡ್. ಅದರಲ್ಲಿ 2,16,4/2016 ಲಾಸ್ಟ್ ಇಂದ 4ನೇ ಮೈಲಾಡ್ ಕ್ಯಾಶ್ ವಿತ್ಡ್ರಾ ಅಂತ ಮಾಡ್ತಾರೆ. 2 ಲಕ್ಷ ಮಾಡಿ ಪುರಾಣ ಕೈಲಿಸಿ 21/5/2016 ಮ್ಯಾನೇಜರ್ ಅದರಲ್ಲಿ 5,80,000 ವಿತ್ಡ್ರಾ ಮಾಡ್ತಾರೆ. ಅವರು ನಮ್ಗೆ ಇಲ್ಲಿ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಾನು ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಯಾವಾಗ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ. ಆ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿರೋದು ಇಲ್ಲ 26/5/2016 ಪ್ಲೆಡ್ಜ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ. ಅವ್ರ ಅಕೌಂಟ್ ಅಲ್ಲಿ 10 ಲಕ್ಷ ಇದೆ, ಅವ್ರ ವೈಫ್ ಅಕೌಂಟ್ ಅಲ್ಲೂ ಅಮೌಂಟ್ ಇದೆ. ಇವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ ಅವ್ರ ವೈಫ್ ಅಕೌಂಟ್ಗೆ.
Is there any cross examination on these documents?
My lord, yes, my lord. Cross examination of Your Honor, kindly see, is admitted the cross examination of one aspect 2/1/2017 in page number 9, para number 15. ನೀಪಿ ಒಂದು ಚೆಕ್ಕಿನಲ್ಲಿ ಮಹೇಶ್ ಆರ್ ಎಂದು ಬರೆದಿರುವುದು ಇಂಕಿಗೂ ಮತ್ತು 9,50,000 ಅಕ್ಷರಗಳಲ್ಲಿ ಬರೆದಿರುವ ಇಂಕಿಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ ಎಂದರೆ ಇರಬಹುದು. ಮೈಲಾರ್ಡ್, ಅವರು ನನ್ನೆದುರಿಗೆ ಚೆಕ್ ಬರೆದ್ರು ಅಂತ ಒಪ್ಕೋತಾರೆ ಇದರಲ್ಲಿ. ಈಗ ಅದರಲ್ಲಿ ಮೈಲಾರ್ಡ್ ಒಂದು ಅವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ 2/2/2017 ಪ್ಯಾರ 7 ಮೈಲಾರ್ಡ್. ನಾನು ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಸಂಸ್ಥೆ ಸರ್ಕಾರಿ ಸ್ವಾಮ್ಯಕ್ಕೆ ಸೇರಿದ ಸಂಸ್ಥೆ ಎಂದರೆ ಸರಿ. ನಾನು ಅದನ್ನ ಸೈಟೇಷನ್ ಓದೋದು ಅದಕ್ಕೆ ಸರ್ ಅಥಾರಿಟಿ. ಅವ್ರು ಅಷ್ಟೊಂದು ಕ್ಯಾಶ್ ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಆಮೇಲೆ ನಂತರ
It is not a sin, sir. Being a government servant, can he not withdraw the amount from his account?
ಬಟ್ ಇನ್ಫಾರ್ಮ್ ದಿ ಇನ್ ಅಥಾರಿಟಿ ಮೈಲಾರ್ಡ್.
The law prohibits
ಅಲ್ಲಲ್ಲ,
that.
ಹೌದು ಮಾಡಬಹುದು ಸ್ವಾಮಿ. ನನಗೆ ತಿಂಗಳಿಗೆ 32,000 ಸಂಬಳ ಬರುತ್ತದೆ ಎಂದರೆ ತೋರಿಸಲು ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲಾತಿ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನನ್ನ ಸಂಬಳ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ನಾನು ನಮ್ಮ ಇಲಾಖೆಯಲ್ಲಿ 22,50,000 ಕೊಟ್ಟ ಬಗ್ಗೆ ಲಿಖಿತ ರೂಪದಲ್ಲಿ ಡಿಕ್ಲರೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ಇಟ್ಸ್ ನಾಟ್ ಎ. ಆಮೇಲೆ ಅಲ್ಲಿ 9 ತಾವು ಹೇಳಿದ್ರಲ್ಲ, ಕೊನೆಯ ಬಾರಿಗೆ 26/5/2016 ಕೊಟ್ಟ ಹಣ ನಾನು ಒಡವೆ ಮಾರಿ ಇಟ್ಟುಕೊಂಡಿದ್ದೆ ಎಂದರೆ ಕೊಟ್ಟಿದ್ದೆ. ಸದರಿ ಒಡವೆಗಳನ್ನು ನಾನು ತಮಿಳುನಾಡಿನ ಕೃಷ್ಣಗಿರಿಯಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿರುತ್ತೇನೆ. ಸದರಿ ಒಡವೆಗಳನ್ನು ನನ್ನ ಅಣ್ಣನಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತೇನೆ. ನಾನು ಕೇಳಿಸಿ ಎಕ್ಸಿಬಿಟ್ P9 ಮೈಲಾರ್ಡ್. ಎಕ್ಸಿಬಿಟ್ P9 ಅದರಲ್ಲಿಲ್ಲ. ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P9 ಈಗ ಅವರ ವೈಫ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ 26/5 ಮೈಲಾರ್ಡ್. 21 ಡೆಪಾಸಿಟ್ 16,78,175 ರೂಪಾಯಿ 16/4/2016 ಆಗುತ್ತೆ. ತಿರ್ಗಾ ಇವರೇನೆ ಅವ್ರ ಹಸ್ಬೆಂಡ್ 16/4/2016 2 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. 30/5/2016 ಅವ್ರ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಬ್ಯಾಲೆನ್ಸ್ 10,511 ರೂಪಾಯಿ ಇದೆ.
ದಯವಿಟ್ಟು if you have anything to say regarding rebuttal of the presumption, please address the argument. Otherwise, I will proceed.
But
Enough is enough.
ಇಲ್ಲ ಮೇಡಮ್.
Don't be under the impression that I will go on hearing you.
Your Honor, kindly see, is admitted in cross examination.
You rebutted the presumption. If yes, how?
I am not obtained any loan from the appellant, my lord. Is no liability to pay the amount.
Yes, anything in reply?
Now, so far as the rebuttal is concerned, my lord, the law is well settled. Therefore, it is in case of Hiten P. Dalal versus Batindranath Banerjee, the Supreme Court, in the case of in this case, my lord, has held that presumption that the check was drawn for discharge of liability drawer ought to be raised by the court in every case. Rebuttal evidence, nature, mere plausible explanation is not sufficient. Proof of explanation is necessary.
Yes.
And so far as the writings in the check is concerned, in the case of Bir Singh versus Mukesh Kumar, 2019 Part 4 SCC 197, the Supreme Court has held that if the signature in the check is admitted, that is sufficient, and whether who has filled the check is immaterial. That is the view taken by the Supreme Court.
In cross-examination of the appellant is admitted, I'm not asking the any interest in remaining amount till today is no legal action against me, my lord, is no class. ಇನ್ನು 13 ಲಕ್ಷಕ್ಕೆ ಏನು ಅವರು ಲೀಗಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸೇ ಮಾಡಿಲ್ಲ 2016 is a hug amount. If we genuinely paid to the respondent, in not prosecution against respondent, several doubt, my lord.
Why you are placing reliance on Krishna Janardhan Bhatt? That was the decision relied on by the first appellate court.
Yes, my lord.
How it is helpful?
An accused for discharging the burden of proof placed upon him under a strict need not to examine himself. He may discharge his burden on the basis of the materials already brought on record. On accused as constitutional right to maintain silence, standard of proof on a part of the accused and that of prosecution in a criminal case is different. ಇದರಲ್ಲಿ ಆ ಸೈಲೆಂಟ್ ಆಗಿ ಇರ್ಬೋದು ಅಂತ ಹೇಳಿದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ. So is
that has been clarified by the Supreme Court in Rangappa versus Mohan.
ಅದರಲ್ಲಿ ರಂಗಪ್ಪ ಮತ್ತು ಇದರಲ್ಲಿ ಅದ್ರ ಬೇರೆ ಕೇಸ್ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್, ಮೈ ಲಾರ್ಡ್.
ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲದು ಬೇರೆನೆ.
ಬಟ್ ಪ್ರಿನ್ಸಿಪಲ್ ಆಫ್ ಇದರಲ್ಲಿ ಅವನು ಲೋನ್ ತಗೊಂಡಿರ್ತಾರೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಅವರು.
Appeal is allowed. Yes.
Figure number 90, final hearing, HM Manjesh.
To appear for the respondent in this case, 2 weeks time, lordship.
Could you order sheet? Could you? Appellant, where is he?
I am for the respondent.
Very good. Finally, ಎಲ್ಲಿದೆ? ಅದಾಯ್ತು, ಫೈನಲಿ ಎಲ್ಲ ಆಗಿದೆ. NBW that was issued to the respondent was recalled at
Yes,
your
sir.
instance. Even then, you are not ready to address the
Lordship,
argument.
what happened, lordship, I filed the wakalat and
I am not concerned
no,
about
lordship,
it.
I didn't have the file, lordship, I will
Then
take.
why you filed the wakalat?
No, lordship.
Without file, why you filed the wakalat? Why you accepted the brief?
Lordship, today, if they come, lordship, I will take the file and address the argument.
Hardly noted. Pass over. Next.
20, Vasant Vincent, G1 case.
For the appellant.
Here I appear for the respondent.
Good.
Yes. For my argument, I seek one big time. That's it.
Who moved the matter? You moved the matter. Then counsel for the appellant moved the matter. He is ready to address the argument. Then counsel for respondent prays for time. Appeal is of the year 2021. Both the learned counsel undertake to address their arguments on the next date of hearing without fail. Submission is placed on record, list finally as the last chance. On the next date of hearing, both of you please get ready and address the next.
Serial number 21,
My lord,
P.S. Basuraju, C.R.
Lord, may-
Raghavan.
may I interrupt? A date has been
Date,
fixed.
put the date to, from the court officer, you take the date. We'll give you. 21,
Yes, sir. Yesterday itself, I got the certain documents, my lords. I have to file the additional grounds and along with additional document. This is up to 2022, my lords. The 155 surplus to complaints, I have to file separate order. Several 8 NCRs are being registered against me, my lord. 8 NCRs are registered against me in Unsur. And 2 498A case has been registered. Later it was been withdrawn. I have produced all the document, my lords.
you produce it leisurely, but I will not extend the interim order.
No, my lords.
I am making very clear.
No, sir, I'll argue the matter, my lords.
You can
The
take
date may
the
be given, no, my lords.
learned counsel for the petitioner prays for time. He submits that the additional documents are received and he wants to plead additional grounds in support of his contention. And counsel, yes, what do you say?
Kindly fix the date, any date. We are ready for final arguments on
Finish it up.
Monday itself.
Yesterday I got the certified
Because
copies.
police have filed a clear charge sheet against the accused person.
Counsel for the respondent submits that the police have already filed the charge sheet. And the petitioner who is enjoying the interim order is not addressing the argument. Now, what is the stage before the trial court?
Evidence before charge.
Which is,
Now the matter is pending.
Even last 2 months back also,
Compromise.
petitioner is ready for compromise to give back our property. 2 months they took the time. Again, they are ready for arguments. Even the Mavan
so their conditions,
Aliya
my lords,
Kodaki
they
used
don't
to
want.
I will post it after four weeks.
No, my lords, next week I'll date produce. I will argue, finish it.
Date after 4 weeks, but I will not extend
order.
the interim order. Interim order extend.
I will argue today itself, my lords.
Not extend.
Kindly pass over.
Yes, argue the matter then.
Kindly pass over, my lords. Senior counsel, but kindly pass over.
Pass over. Adenu beda.
For admission, serial number 22, H.K. Singh, R. Vishwanath Rao.
Kudi. Trial court records are received. Counsel for the appellant is absent, no representation. Appeal is of the year 2013. List finally as the last chance. Next.
Serial number 23, B.B. Shivkumar.
Respond
Arvind
number,
Lekro.
for the respond number 2 is for the respond number. Respond number is died on 2014, my lord. I produced the memo along with the certificate. Second respondent is died, ma'am. Appeal memo padi. Appeal memo. The first respondent is a Vaishnavi Jewelers, ma'am. The proprietor of the second respondent, P. Subhas. P. Subhas is died on 2014. The counsel for the respondent filed the memo reporting the death of respondent number 2. The proprietor of respondent number 1. As per the death certificate produced along with the memo, respondent 2 died on 6/6/2014. Appeal is already abated.
I appeal for petitioners, my lord, appellant, my lords.
Huh?
I appeal for appellant, my lords. 99 from short date for.
However, counsel for the appellant prays for time to take steps against this is respondent. List on. Next.
Serial number 24. Ramanya.
Lord, I'm appearing for the appellant in this case, my lord.
Yes.
Lord, permission specially has been granted, my lord. The LCR was called, my lord. It is not received as per the note put by the office, my lord.
Await
Lord,
LCR. Await LCR.
await ಇದೆ. My lord, only ground, my lord, to dismiss my complaint is, my lord, the check was of the series 1990, my lord, 1999. He had mentioned that, my lord, 30th by 2013 at the time of issuing the check. The court noted that.
I will consider that, sir. Merits of the case I will consider once I receive the trial court records.
Please, my lord.
Yes.
Any date, my lord?
Date will be given.
Please, my lord.
Yes.
Madam Date, I'm appearing for a respondent.
Let the trial court records be received. Sir. Next.
Much obliged.
List 3. Non-compliance of office objection for first time. Serial number 1. Dinesh Kumar Rao K.
Counsel for the petitioner is absent, no representation. Next.
Order first time matter. Serial number 2 to 4.
HCGP to take notice for respondent. Private either issue notice.
Serial number 3.
HCGP to take notice. Private either issue notice.
Lords, any date may be fixed, my lords.
Date put the rest.
Great.
Next.
For orders. Serial number 5. Sirajuddin Ahmad.
ಆಯ್ತು ಇದೇನೋ ಮೆಮೊ ಹಾಕಿದಾರಲ್ಲ ವಿಡ್ರಾವಲ್ ಕೊಡಿ. Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record. Petition is dismissed as withdrawn. Idetan. Yes. Next.
Serial number 6. Sunil S. Narayan.
And for the respondent number 2, my lord.
ಡಾಕ್ಟರ್ ರಿಪೋರ್ಟ್ ತರ್ಸ ಕೇಳಿದಾರೆ ಸರ್.
ಹಾ?
ರಿಪೋರ್ಟ್ ತರ್ಸ ಕೇಳಿದ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು.
ಎಲ್ಲಿದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಟರ್? ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು. ಇವಾಗ ಎಲ್ಲೋದ್ರು HCGP? I'll pass over. Later come. ಅಲ್ಲ ಇದನ್ನ ಕರೆದ್ಬಿಡಿ.
Serial number 7. Zamir Pasha.
What is this IA 1 of 2024?
I have not filed any.
Who filed the IA? ಇಲ್ವಾ ಅದು? Here is the application signed by the advocate for petitioner.
Not for dispensation.
Okay, I have not filed on that.
I apologize. Please for that.
ಹೇಳಿದ ಕೂಡಲೇ ಏನಾದ್ರು ಒಂದು ಹೇಳ್ಬಿಡಿ.
I am so sorry, Lord. I am so sorry. Stand corrected.
Why it is to be dispensed with? Why you have not produced certificate copy?
Lord,
When the order was passed, 5/6/2024. You have not applied for certificate copy.
Lord, we had applied one set. Lord, we have also preferred 482 petition. In Lord 482 petition, Lord, this honorable court, Lord, by order dated 20th September, Lord, granted interim order. Lord, not to take any course of action as against the petitioner. Lord, subsequently 41 a notice was issued for Lord appearance and requirement of voice sample. Lord, I appeared before the IO. I gave the voice sample also. Lord, may I pass on this? 41 in. I'm enclosing the order copy in the criminal petition.
By this memo?
Lord, the copy of interim order, my lord.
Certificate copy is produced?
Certified copy, my lord, is submitted to the IO,
IO.
respondent.
You should have produced before the court, not before the
Lord, I will place
proceeding
it,
officer.
yes. I will place it before your lordships also.
Please get it and
Yes.
place it. Counsel for the petitioner prays for time to produce certificate copy of the impugned order. Hence, IA1 of 2024 is disposed of. List on. How many time, how many days you may require?
Lord, for the certified copy of interim order, my lord,
Yes, order passed by the trial court, is it not?
for that, my lord, 2 weeks, my lord, because there is procedure there, my lord, only the petitioner has to apply. We are not on record there.
Who is the petitioner?
Petitioner is a sub-inspector, my lord. But 2 weeks time may be granted, I will place it before your lordship.
2 weeks. He prays
I'm
for
grateful.
2 weeks time.
Please.
Figure number 8, Gopal Singh, Rajendra Desai.
My lords, appearing for respondent number 2, my lords.
Hmm.
Praise 1 week time for filing objections, my lords.
Objections to what? Objections to?
My lords, objection to bail petition, my lords.
Then better Haley in objections, I will take it.
My lords,
I'm for the petitioner.
Yes,
Your lordship, the petitioner was on bail, my lord. Granted
petitioner
by
is accused number,
1, my lord. Sole accused.
sole accused.
Yes, my lord.
When he was arrested,
He was arrested on the registration of the case, my lord. Subsequently, he is arrested on
when he was arrested,
in the case, my lord, main case, he was arrested on the same day on the registration of the case, and he was granted bail by the Honorable Sessions Court, my lord.
date illo gothilva.
Yes, my lord. Date of arrest.
my lords,
15/4/2023.
Huh?
15/4/2023.
2023, what is the offense?
Offense is under section 376, 504 and 509, my lord. 506, 504 and 376 of
Charge sheet
IPC.
is filed.
Pardon?
Charge sheet is filed.
Charge sheet is filed.
What is the stage before the trial court?
My lord, he was granted bail by the Honorable Sessions Court, my lord. Thereafter, they applied for cancellation of bail. This Honorable Court had cancelled his bail, my lord, citing that a case under section 506 was registered subsequent to the filing of the case, my lord. The primary case, the principal case, my lord. He was given the notice, my lord, but before he could file his wakalat, my lord, the matter was taken up, and when he filed his wakalat, it was on a late, my lord. So he was not represented.
It
when
was cancelled.
Bail was cancelled by this court.
Then when he was, when he surrendered or when he was.
27/7/2024.
27/7/20.
2024. Since then, he is in jail, my lord.
What is the reason for cancellation?
A case was registered in 563. crime.
Violation of conditions.
Yeah, they registered a case that she was threatened to withdraw the case, my lord. That case was registered against 5 people who was not, this petition was not a party.
Mean to say there is
A case was
violation of
registered, yes,
conditions.
yes.
Huh.
On the basis that an FIR was registered for offense under section 506 in the same police station on 4/8/2023. The bail was sought to be cancelled.
When the
First-
bail was granted to him,
Bail was granted on 17/5/2023, my lord. They approached the Sessions Court first, my lord. There they did not succeed. Then they came before this honorable court. Notice was ordered, but
FIR in crime number
563 of 2023,
563 of 2023, that is on 4/8
4/8/2023,
for the offense 506.
506.
Clear case of violation of conditions.
This case was registered not against this petitioner, my lord. His name was included later on. The original case was registered against 4 other.
Maybe, but admittedly you are an
But
accused. in
no,
that
my lord,
case.
this is a false case only to intimidate.
Sir, every case is false case.
My lord, in this
Every
case,
crime registered by the police are false case.
my lord, what happened?
They are the false cases.
My lord, he is a carpenter by profession. He was working with the husband of the respondent number 2, my lord. They are all carpenters, my lord. They are from Rajasthan, from the same community, and they are relatives, my lord.
Now,
It pardon me?
are you challenging that order or seeking grant
I'm
of bail?
seeking bail.
What happened to, what should happen to the order?
That has to be challenged. It has to be challenged before the Supreme Court, my lord. There was no opportunity to defend, my lord. Before he could file his vocal.
If that is the case, you should have challenged that order.
Yes, my lord, but I need to go to Supreme Court. my lord. Actually, his marriage was on 11/7, my lord. The matter was taken up on 16/7. He could not go and file the wakalat, my lord. And when the wakalat was filed, this matter has been disposed, my lord.
Yes, what do you say?
My lords, my submission is that, my lords, at ground paragraph number 9 in the petition, my lords, they have stated that, my lords, that no proper opportunity was given to the petitioner in the defending his liberty. The orders of the cancellation of the bail is against the principle of natural justice and his liberty was taken away arbitrarily, my lords. They are supposed to challenge this order, my lords, the bail cancellation orders, my lords. Instead that, my lords, they have filed a fresh bail petition, my lords. My lords, in the bail cancellation order also, my lords, dated 16th July 2024, my lords, your lordship has
Where is
mentioned.
that order, page number?
Which
Cancelling the bail?
page number 168, sorry. 111, Milord. Page number 111.
My lords, in that order, my lords, paragraph number 7, my lords, page, my lords, this honorable court has rightly mentioned, my lords, it is also pertinently note that in spite of the service of the notice, respondent number 1, he has chosen to remain absent and unpresented before this honorable court, my lords. On these ground, my lords, the bail was cancelled, my lords. My lords, and this, my lords, the crime number 563, my lords, clearly states that, my lords, they have threatened the victim, my lords.
Victim.
Yes, my lords.
Milord, this is not the case, Milord. There was no connect after the registration of the case, Milord. He has no connect at all, Milord. Milord, the problem is with the husband of,
What is the stage?
now it has been committed, Milord.
Let
Committed,
the victim be examined. Later we'll consider.
it will take more time, Milord. He is a married person, has children, Milord. He is a carpenter by profession.
Maybe.
He never involved into any case, Milord.
But he should not have ventured to.
He did
threaten
not,
the
Milord. He did
victim.
not, Milord. Milord, this case was registered for, before the charge sheet was filed, Milord. If that was the genuine case, it was the same police who filed the charge sheet later on, Milord. They have not given any such writing.
Sir, I can understand if you had addressed this argument while considering
I
criminal.
agree, Milord, but
1638.
because it was late, Milord, he could not
ಆಯ್ತು,
file the.
change ಮಾಡೋಣ.
Milord, he's since 4 months he's in custody. He was on bail previously, Milord. He did not violate any conditions.
Threatening the victim in a case involving 376 is of very serious nature.
Milord, he did
We
not,
cannot
Milord.
ignore that.
The FIR was not registered against him, Milord.
That is the general
Against some-
submission, sir.
Against some 4%.
I have not found a single advocate saying that, yes, my client has committed an offense.
Milord, if I was the threatener, Milord, she could have given the case against me, Milord. She has not named me, Milord, in the FIR.
Where is the FIR? Victim in the present case is the complainant
Yes, Milord.
in that case.
Pardon?
Subsequent FIR,
Yes, Milord. My name is not there, Milord.
where is the FIR?
I see.
It is against whom?
Some Kanaram, madam. He is also not relative to me. They are all community people, Milord.
Kaluram.
Kanaram, Milord.
ಎಲ್ಲಿದೆ FIR ಇಲ್ಲಿ?
One minute.
Maybe at your instance, somebody else must have.
No,
threatened the
Milord,
victim.
even not that case, Milord.
ಎಲ್ಲಿ FIR?
Yes,
ಇದೆ?
Milord.
My lords, in the same crime, my lords, order dated 4/9/23, my lords, this
I know.
accused Rupar name, I was sought permission to include this accused name, my lords, and that was allowed, my lords. It was also mentioned in the bail cancellation order, my lords, at paragraph number 5.
The names are Kanaram, Umaram, Rameshwar, Siran, and Manish, Milord. Either my presence or I was appearing there, there is no mention at all, Milord, that this petitioner had any role in that FIR, Milord. And this is registered by the same police, Milord.
Admittedly, you are an accused in that case.
They later on added my name, Milord, in the charge sheet. Milord, this is the same police who had taken this FIR, and the charge sheet in the rape case was filed later.
First of all, you have not produced that FIR.
Yes, Milord, I have. I'll submit.
Secondly, I have referred to an order dated 4/8/2023 passed by the trial court, permitting the victim to implead you as an accused.
As an
That
accused.
order is not produced.
I'll produce it, Milord.
Then simply saying, I have not committed any offense,
I'll get,
falsely implicated,
I'll get
how
that.
that will serve any
I understand.
purpose?
I understand. I'll get it.
ಕೇಳಿದಾಗ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು sir.
I understand, Lord. It is there, but I could not produce in the records.
Why should I suggest all these things?
No, it was
You are an advocate, not the.
I understand.
Not the petitioner is not my client.
Yes,
You should understand what is to be produced, what is to be submitted.
yes, I'll get it.
ಏನು ಇಲ್ಲ, false case, false case. Very strange.
Yes, I'll get it.
Counsel for the petitioner prays for time. Prays for 2 weeks' time. Next. Next.
Serial number 10, Nayak Venkatraman Nagappa.
ಇದೇನಾಯ್ತು? 9 ಏನಾಯ್ತು? 9. Serial number 9. Serial number 9?
9.
Yes.
439 petition.
Who is the petitioner?
Petitioner is accused number 2, my lord.
Accused number 2.
Accused number
In all, how many accused are there?
13 accused.
When he was arrested?
Lord, 6/5/2020. 6/5/2024.
24. What is the offense?
Lord, 320, 312, 313, 314 and 3. FIR, my lord, is at page 22 is the complaint. Lord, on 6/5/2024, my lord, the one Bettaswamy is the district family welfare officer.
ಇದು ಮಂಡ್ಯದ ಇದು.
Monday, the termination of pregnancy, my lord. The only allegation this person, my lord, he is the husband of accused number 1, my lord. He has assisted in termination of, assisted the accused number 1 in termination of pregnancy.
Then serious.
Lord, Lord, it is in the house, my lord, he has been arrested, my lord, he has
Petitioner is the husband of. accused
husband
number
of
one.
accused number 1. And Lord, and accused number 3 also mother of the accused number 1, 3.
Accused number 3 is the mother of
Accused number 1.
1.
And allegation her.
Entire family is involved in this.
No, the allegation, Lord, on the, so far as A3 is concerned, she has been enlarged on bail, my lord, by the, granted by the trial court, my lord. Annexure C, my lord, page 218, it is granted by trial court itself, my lord. Lord, the others accused also been enlarged by the, on the accused, my lord. This only he is the husband, my lord, he is in the house, my lord, that other than, my lord, it is the night they have conducted, my lord. The allegation, my lord, which is allegation leveled against this person, my lord, it is only as he has not played any role, my lord.
Read the column number 17.
17, my lord.
What is the role attributed to you?
There is nothing has been elicited, my lord. The only, it's other accused, my lord. Any last para, my lord. Last page 60. It commencing from page 58, my lord. And it's interesting. There is no whisper about this accused. ಲಾಸ್ಟ್ ಅಕ್ಯೂಸ್ ಆರೋಪಿ 6-7-13 ಸ್ನೇಹಿತರವರ ಬಳಿ ಭ್ರೂಣ ಪತ್ತೆ ಮಾಡುವ ಸ್ಕ್ಯಾನಿಂಗ್ ಮೆಷಿನ್ಗಳು ಅಕ್ರಮವಾಗಿ ಇಟ್ಟುಕೊಂಡು ಗರ್ಭಿಣಿ ಹೆಂಗಸು ಕಾನೂನಾಗಿ ಪತ್ತೆ ಮಾಡುತ್ತಿದ್ದು ಇವರುಗಳ ಬಳಿಗೆ ಹೆಂಗಸರು ಸಂಪರ್ಕ ಮಾಡಿಕೊಂಡು ಬರಲು ಆರೋಪಿ 8, 9, 10, 11 ಮುಖಾಂತರ ಕರೆಸಿಕೊಂಡು ಕಾನೂನಾಗಿ ಪತ್ತೆ ಮಾಡಿದ ಇವರುಗಳಂತ ಆರೋಪಿ 1, 2, 3, 4 ಅವರುಗಳ ಬಳಿಗೆ ಹೆಣ್ಣು ಭ್ರೂಣವನ್ನು ಕಾನೂನಾಗಿ ಗರ್ಭಪಾತ ಮಾಡಲು ಗರ್ಭಿಣಿ ಹೆಂಗಸರು ಕಳಿಸಿಕೊಟ್ಟರು. This only allegation has been implicated on the last, my lord.
Yes, what do you say?
My lord, the allegation against this petitioner is at page number 60, my lord, from the starting paragraph. First line, my lord, the last words, my lord. ಆರೋಪಿ 1ರವರ ಬಳಿಗೆ ಹೋಗುವಂತೆ ತಿಳಿಸಿ ಸ್ಥಳದಿಂದ ಹೊರಟು ಹೋಗಿದ್ದು, ನಂತರ ಆರೋಪಿ 1ರವರ ಮೊಬೈಲ್ ನಂಬರ್ಗೆ ಸಾಕ್ಷಿ 2ರವರು ಫೋನ್ ಮಾಡಿ ಎಲ್ಲಿಗೆ ಬರಬೇಕೆಂದು ಕೇಳಿದ್ದು, ಆಗ ಆರೋಪಿ 1ರವರು ಸಾಕ್ಷಿ 2ರವರಿಗೆ ಪಾಂಡವಪುರ ಟೌನ್ ಗ್ಯಾಸ್ ಗೋಡೌನ್ ಬಳಿ ಬಂದು ವೇಟ್ ಮಾಡಿ ಎಂದು ಹೇಳಿದ್ದು, ನಂತರ ಆರೋಪಿ 1ರವರು ತನ್ನ ಮತ್ತೊಂದು ಫೋನ್ ನಂಬರ್ನಿಂದ ಆರೋಪಿ 2ರವರ ಫೋನ್ಗೆ ಫೋನ್ ಮಾಡಿ ಗ್ಯಾಸ್ ಗೋಡೌನ್ ಬಳಿ ಒಬ್ಬಳು ಗರ್ಭಿಣಿ ಹೆಂಗಸಿದ್ದಾಳೆ, ಅವಳಿಗೆ ಅಬಾರ್ಷನ್ ಮಾಡಬೇಕು. ಅವಳನ್ನು ಸಾಕ್ಷಿ 12ರವರ ಲಾಡ್ಜ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಇರಿಸಿ ಎಂದು ಹೇಳಿದ್ದು. ಅದರಂತೆ ಆರೋಪಿ 2ರವರು ಸಾಕ್ಷಿ 2ರವರನ್ನು ಪಾಂಡವಪುರ ಟೌನ್ NJR ಲಾಡ್ಜ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಇರಿಸಿದ್ದು. ನಂತರ ಆರೋಪಿ 1ರವರು ತನ್ನ ಫೋನ್ ನಂಬರ್ ಇಂದ ಆರೋಪಿ 4ರವರ ಮೊಬೈಲ್ಗೆ ಫೋನ್ ಮಾಡಿ ಲಾಡ್ಜ್ ಬಳಿ ಹೋಗಿ ಸಾಕ್ಷಿ 2ರವರನ್ನು ಆರೋಪಿ 1ರವರ ವಾಸದ ಮನೆಯಾದ ಸೋನ್ಸೋಗೆ ಕ್ವಾರ್ಟರ್ಸ್ಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ಗರ್ಭಪಾತ ಔಷಧಿ ಕೊಡುವಂತೆ ತಿಳಿಸಿದ್ದು. This is the allegation, my lord. He is the husband of the accused number 1. And according to her directions, my lord, he has taken the victim to the lodge.
Allegations are made. ಏನು ಇಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
My lord, it is not substantial, my lord. There is
Serious allegations against accused number 1 and 2, my lord. Accused number 3 is the mother, my lord. Is an old lady. The bail has been granted.
What is the allegation against accused number 3?
3, she has given the tablet for the victim, my lord. She has received 15,000 from CW2. ಅಲ್ಲೇ ಮುಂದೆ, my lord. ಅದರಂತೆ ಆರೋಪಿ 4ರವರು ಲಾಡ್ಜ್ ಬಳಿ ಹೋಗಿ ಸಾಕ್ಷಿ 2ರವನ್ನು ಹೆಲ್ತ್ ಕ್ವಾರ್ಟರ್ಸ್ಗೆ ಗರ್ಭಪಾತದ ಔಷಧಿ ಕೊಡಲು ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದು. ಆಗ ಕ್ವಾರ್ಟರ್ಸ್ನಲ್ಲಿದ್ದ ಆರೋಪಿ 3 ಸಾಕ್ಷಿ 2ರವರಿಂದ 15,000 ಹಣವನ್ನು ಅಬಾರ್ಷನ್ ಮಾಡಲು ಪಡೆದುಕೊಂಡಿದ್ದು. ನಂತರ ಆರೋಪಿ 4ರವರು ಸಾಕ್ಷಿ 2ರವರಿಗೆ ಅಬಾರ್ಷನ್ ಮಾತ್ರೆಗಳನ್ನು ಕೊಟ್ಟು ಹೊಟ್ಟೆ ನೋವು ಬರುವವರೆಗೆ ಲಾಡ್ಜ್ನಲ್ಲಿ ಇದು ವಾಪಸ್ಸು ಬರುವಂತೆ ತಿಳಿಸಿದ್ದು. ಅದರಂತೆ ಸಾಕ್ಷಿ 2ರವರು ವಾಪಸ್ ಲಾಡ್ಜ್ಗೆ ಹೋಗಿದ್ದು. ನಂತರ ಸಾಕ್ಷಿ 2ರವರಿಗೆ 9 ಗಂಟೆಗೆ ಹೊಟ್ಟೆ ನೋವು ಬಂದಾಗ ಆರೋಪಿ 1ರವರಿಗೆ ಫೋನ್ ಮಾಡಿಕೊಂಡು ಲಾಡ್ಜ್ನಿಂದ ಸಾಕ್ಷಿ 2, 3 ಹೆಲ್ತ್ ಕ್ವಾರ್ಟರ್ಸ್ಗೆ ಬಂದಿದ್ದು. ಆಗ ಹೆಲ್ತ್ ಕ್ವಾರ್ಟರ್ಸ್ನಲ್ಲಿದ್ದ ಆರೋಪಿ 1ರಿಂದ 4ರವರುಗಳು ಸೇರಿಕೊಂಡು ಸಾಕ್ಷಿ 2ರವರಿಗೆ ಅಬಾರ್ಷನ್ ಮಾಡಲು ಔಷಧಿಗಳನ್ನು ನೀಡಿ ಗರ್ಭಪಾತ ಮಾಡುತ್ತಿದ್ದು. ಆಗ ರಾತ್ರಿ 11:30 ಗಂಟೆ ಸಮಯಕ್ಕೆ ದೋಷಾರೋಪಣಾ ಪತ್ರದ ಕಾಲಂ ನಂಬರ್ 14 ನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸಾಕ್ಷಿ 1, 4, 5, 7, 8, 9, 42 ಹಾಗೂ 58ರವರುಗಳು ದಾಳಿ ಮಾಡಿ
victim statement has been recorded, my lord. This is page 63. In her statement, she has not stated anything against this person, ma'am. Yes, lord, on the same set of allegation, my lord, the accused number 3 is been granted bail, my lord. And
ಫಸ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ, ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ
statement, my lord,
ಪ್ಯಾರಿಟಿ ಅಂತ ಇದ್ರಿ.
the ground of parity. In statement, my lord, victim statement, page 63, kindly please. 63, she has given statement, my lord.
There will be statement and further statement.
There is no further statement.
Page number?
Page number 63, my lord.
60?
63. Bottom, ದಿನಾಂಕ 23/4/2020, ಥರ್ಡ್ ಪ್ಯಾಚ್. ಗಂಡ ನವೀನ್ ಕುಮಾರ್ಗೆ ಫೋನ್ ಮಾಡಿ ಎಲ್ಲಿಗೆ ಬರಬೇಕೆಂದು ನವೀನ್ ಪಾಂಡವಪುರ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗೆ ಬಂದು ಫೋನ್ ಮಾಡುವ ನಂತರ ಶಿವಲಿಂಗನ ಸ್ಕ್ಯಾನ್ ಮಾಡಿಸಲು ಪಾಂಡವಪುರ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದು. ಆಗ ಅಲ್ಲಿಗೆ ನವೀನ್ ಕುಮಾರ್ ನಮ್ಮ ಬಳಿ ಬಂದು 20,000 ದುಡ್ಡು ಕೊಡಿ ಎಂದು ಕೇಳಿದರು. ಆಗ ನನ್ನ ಗಂಡ ಪಾಂಡವಪುರ ಬಸ್ ನಿಲ್ದಾಣದ 20,000 ದುಡ್ಡು ನವೀನ್ ಕುಮಾರ್ ಕೊಟ್ಟಿದ್ದರು. ನವೀನ್ ಕುಮಾರ್ ಅವರು ಆತನ ಬೈಕ್ ಮುಂಭಾಗ ಕೂರಿಸಿಕೊಂಡು ಕಾರನ್ನು ಫಾಲೋ ಮಾಡಿಕೊಂಡು ಗಂಡನ ಆತನ ಹಿಂದೆ ಬರುವಂತೆ ತಿಳಿಸಿದರು. ನನ್ನ ಗಂಡ ಬೈಕ್ ನಲ್ಲಿ ನನ್ನ ಹಿಂದೆ ಬಂದರು. ನಂತರ ನವೀನ್ ಕುಮಾರ್ ನನ್ನನ್ನು ಬನಘಟ್ಟ ದೇವಸ್ಥಾನದ ಬಳಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಗಂಡನಿಗೆ ಅಲ್ಲೇ ಇರಿ ಎಂದು ಹೇಳಿ ನನ್ನನ್ನು ಮಾತ್ರ ಬೈಕ್ ನಲ್ಲಿ ಒಂದು ಕಾರು ಫಾಲೋ ಮಾಡಿಕೊಂಡು ಕರೆದುಕೊಂಡು ಬಂತು ಎಲ್ಲೆಲ್ಲಿ ಸುತ್ತಾಡಿಸಿ ತೋಟದ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದ್ರು. ಅಲ್ಲಿ ಮನೆಯಲ್ಲಿ ಅಭಿ ಎನ್ನುವರು ಹಾಗೂ ಹೆಂಡತಿ ಮನೆಯಲ್ಲಿ ಇದ್ದು ಅಲ್ಲಿ ಮಂಚದ ಮೇಲೆ ನನಗೆ ಅಭಿ ಎನ್ನುವರು ಸ್ಕ್ಯಾನಿಂಗ್ ಮಷೀನ್ ಇಂದ ಹೊಟ್ಟೆಯನ್ನು ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿದರು. ನಂತರ 90% ನಿಮಗೆ ಗಂಡು ಮಗು ಅನಿಸ್ತಂತೆ ಎಂದು ಸರಿಯಾಗಿ ಗೊತ್ತಾಗುತ್ತಿಲ್ಲ, ಇನ್ನೊಂದು ಸಾರಿ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಬೇಕೆಂದು ಹೇಳಿದರು. ನಂತರ ನವೀನ್ ಕುಮಾರ್ ನನ್ನನ್ನು ಬೈಕ್ ನಲ್ಲಿ ಬನ್ನರ್ಘಟ್ಟ ದೇವಸ್ಥಾನದ ಬಳಿ ಕರೆದುಕೊಂಡು ವಾಪಸ್ ಕರೆದುಕೊಂಡು ನನ್ನ ಗಂಡ ಬಳಿ ಬಿಟ್ಟು ಮತ್ತೆ 10 ದಿನ ಬಿಟ್ಟು ಬನ್ನಿ ನವೀನ್ ಕುಮಾರ್ ಹೇಳಿದರು. ನಂತರ ಯಜಮಾನರ ಜೊತೆ ನಾನು ವಾಪಸ್ ಊರಿಗೆ ಹೊರಟಿ ಹೋದೆನು. ದಿನಾಂಕ 5/5/2024 ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 7:45 ಗಂಟೆ ನನಗೆ ಅಭಿ ಆಗಾಗ್ಗೆ ಕೊಟ್ಟಿದ್ದ ಅವರ ಮೊಬೈಲ್ ನಂಬರ್ಗೆ ನನ್ನ ಗಂಡ ಮೊಬೈಲ್ ನಂಬರ್ ಹೋಗಿ ಫೋನ್ ಮಾಡಿದಾಗ ಅವರು ಪಾಂಡವಪುರಕ್ಕೆ ಬನ್ನಿ ಅಂತ ತಿಳಿಸಿದರು. ಅದರಂತೆ ನನ್ನ ಗಂಡ ಶಿವನಾಯಕ ನನ್ನನ್ನು ಮತ್ತು ಚಿಕ್ಕಮ್ಮ ಅಂದರೆ ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ತೋರಿಸಲಿ ಎಂದು ಹೇಳಿ ನನ್ನ ಗಂಡ ಪಾಂಡವಪುರ ಕರೆದುಕೊಂಡು ಬಂದು ಅಭಿ ಹೇಳಿದಂತೆ ಬನಗಟ್ಟ ದೇವಸ್ಥಾನ ನಿಂತುಕೊಂಡೆವು. ಅಲ್ಲಿ ಬೇರೊಂದು ಹುಡುಗನನ್ನು ನನ್ನೊಂದು ಯಾವ್ದು ಬಿಳಿ ಬಣ್ಣದ ಕಾರ್ನಲ್ಲಿ ಕಳಿಸಿದರು. ನಂತರ ನನ್ನ ಹುಡುಗನ ಕೂರಿಸಿಕೊಂಡು ಬೇರೆ ಗರ್ಭಿಣಿ ಬರೀ ಯಾವುದೋ ಒಂಟಿ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದನು. ಕಾರಿನಲ್ಲಿ ಸುಮಾರು 2-3 ಜನ ಬೇರೆ ಗರ್ಭಿಣಿ ಹೆಂಗಸು ಇದ್ದರು. ಅಲ್ಲಿ ಅಭಿ ಇದ್ದರು. ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಸ್ಕ್ಯಾನಿಂಗ್ ಮಷೀನ್ ಇಂದ ಹೊಟ್ಟೆ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ, ಹೆಣ್ಣು ಮಗು ನೀನು ಉಳಿಸ್ಕೊಳ್ತೀಯ ಅಂತ ಎಂದು ಹೇಳಿದರು. ಅದಕ್ಕೆ ನಾನು ನನ್ನ ಗಂಡನ ಕೇಳಬೇಕು ಹೇಳಿದೆ. ನಂತರ ಅಭಿ ಅವರು ಇಬ್ಬರು ಗಂಡಸರು ಇವರನ್ನು ವಾಪಸ್ ಬನ್ನರಘಟ್ಟ ದೇವಸ್ಥಾನ ಇದ್ದ ಗಂಡನ ಬಗ್ಗೆ ಕರೆದುಕೊಂಡು ನಂತರ ಹೆಂಡತಿಯ ಹೊಟ್ಟೆಯಲ್ಲಿ ಇರುವುದು ಹೆಣ್ಣು ಮಗು ಎಂದು ಹೇಳಿದರು. ನನ್ನ ಗಂಡ ಈಗಾಗಲೇ 2 ಹೆಣ್ಣು ಮಗು ಇದು ಪುನಃ ಹೆಣ್ಣು ಮಗು ಜನರು ಆಡಿಕೊಳ್ಳುತ್ತಾರೆ ಎಂದು ಹೇಳಿ ನನ್ನ ಮಗುವನ್ನು ತೆಗಿಸಿ ಎಂದು ಹೇಳಿದರು. ಆಗ ಅಭಿಯ ಪರಿಚಯ ಇರುವವರ ಬಳಿ ಕಳಿಸುತ್ತೇನೆ, ಅಲ್ಲಿಗೆ ಹೋದರೆ ಅಬಾರ್ಷನ್ ಮಾಡಿಸುತ್ತಾರೆ, ಅವರಿಗೆ ದುಡ್ಡು ಕೊಡಿ ಎಂದು ಹೇಳಿದರು. ಆಗ ಅಭಿಯು ಒಂದು ಫೋನ್ ನಂಬರ್ ಅನ್ನು ಕೊಟ್ಟು, ನೀವು ಪಾಂಡವಪುರ ಟೌನ್ ಗ್ಯಾಸ್ ಗೋಡನ್ ಪಕ್ಕ ಇರೋ ಲಾಡ್ಜ್ ಇದೆ, ಅಲ್ಲಿಗೆ ನಂಬರ್ ಕೊಡಿ ಎಂದು ಹೆಂಗಸ್ ಮಾತಾಡಿದೆ ಎಂದು ಹೇಳಿದರು. ಹಾಗೆ ಎಂದು ಹೇಳಿದರು. ನಂತರ ಅಭಿ ಗಂಡನು ಪಾಂಡವಪುರ ಬಸ್ ನಿಲ್ದಾಣ ಕರೆದುಕೊಂಡು ನಂತರ ಅಭಿ ಕೊಟ್ಟಿದ್ದ ಫೋನ್ ನಂಬರ್ಗೆ ಮಾಹಿತಿ ಕಳಿಸಿದ್ರಿಂದ ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಟು ನನ್ನನ್ನು ಚಿಕ್ಕಪ್ಪ ದೇವಮ್ಮ ಗ್ಯಾಸ್ ಗೋಡನ್ ಬಳಿ ಕಳಿಸಿ ನನ್ನ ಗಂಡ ಅಲ್ಲಿಯೇ ಬಿಟ್ಟು ಹೋದ್ರು. ಆಗ ನನ್ನ ಚಿಕ್ಕಮ್ಮ ಎದುರು ನಡೆದಾಗ ನಿಜ ಹೇಳಿದಾಗ ನನ್ನ ಚೆನ್ನಾಗಿ ಬೈದರು. ನಾವು ಗ್ಯಾಸ್ ಗೋಡನ್ ಬಳಿಗೆ ಹೋದ್ರು. ಅಲ್ಲಿಗೆ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಬಂದು ಆಸ್ಪತ್ರೆ ಕಡೆಯವರು ಎಂದು ಹೇಳಿದ್ರು. ನಾವು ಹೌದು ಎಂದು ಹೇಳಿದಕ್ಕೆ ಅವರು ನಮ್ಮನ್ನು ಲಾಡ್ಜ್ ಕರ್ಕೊಂಡು ಹೋಗಿ 106 ರೂಮ್ ಕಳಿಸಿದ್ರು. ನಂತರ ನಾನು ಸಂಜೆ ಪರ್ಸನ್ ಕೊಟ್ಟಿದ ನಂತರ ಮೊಬೈಲ್ ನಂಬರ್ಗೆ ಫೋನ್ ಮಾಡಿದೆವು.
Same thing.
The gravity of the offense, my lord, the comparatively, my lord, insofar as A3 is concerned, my lord. My lord, A3 other than the serious in nature, insofar as accused number 3 is concerned, my lord. The same.
The entire family is involved in this.
Oh, my lord, it's allegation, my lord, not, my lord, my lord, the prosecution has filed the charge sheet, my lord, the investigation is completed, my lord. That too, my lord, is on the same, my lord, the assisted the.
What else is necessary, sir?
My lord, it has to be tested, my lord, the charge sheet is filed, my lord, the entire investigation is.
Children ಇಲ್ದೇ ಇದ್ಮೇಲೆ ಮುಂದೆ ನೀವು ಹೇಗೆ ಸರ್ವೈವ್ ಆಗೋರು? ಗರ್ಲ್ಸ್ ಬೇಡ ಅಂದ್ಮೇಲೆ ಬರೀ ನಿಮ್ದೇ ಸಾಮ್ರಾಜ್ಯನ? Is it not a cruel thing?
Yes.
Then ಹೇಗಿರ್ತೀರಿ? Where is the order in favor of accused number 3?
Lord, annexure C, my lord, page 289. Page 289, annexure C, my lord. Page 8, para 11, 296. The fact that the accused number 1 and 2 are husband and the wife of the accused number 3 is the mother of the accused number is not in dispute. As per the material and record present at the spot at the time of raid and the quarters of accused number, however, active role in the legal termination pregnancy needs to be decided at the time of full trial. The material on record would show that the working as contract based upon so at quarters has provided controversial rules. However, scope of petition very limited. The material collected by investigation would show that the were being husband and indulged in the illegal termination for use of quarters for government hospital. Therefore, the owner to heinous nature in the way of this marriage and ground granted. It is allegation that the accused number 6 and Spalata accused number subject her to illegal termination, breaking this role of protection for assisted her. So, in circumstance of the case, the court of appeal and then accused to her a large bail, they will commit similar appearance, which will be endangered as well. It is argued from the day on the accused number 1 and 3 are in judicial case. This fact is not in dispute. However, the settled position law, the incarnation person is not a ground.
Observation of para number 12.
The material on record, para number 12. The material on would
12
show
and 13. 12 ಅಲ್ಲ ಹೇಳ್ತಾರೆ.
Material records show that though the accused number working contract based at Pandapur subdivision, the quarters was provided her for conformity with rules. However, the scope of it is very limited. The material that collected investigation would reveal that the accused number 1 and 2 being husband and wife are indulged in the illegal termination pregnancy by making use of quarters of government hospital. Therefore, the accused number 1 and 2 are heinous in nature. The in view of matter filing charge sheet alone is not granted for purpose. It is alleged that accused and Kushala the accused number subject termination of pregnancy. Thus, the role of the accused number parent accused number 2 assisted the role of Malot The accused number one apprehended, accused number two assisted her in the given circumstance of the case. The accused number opinion that the accused number one were released on bail. Again, they will commit a similar type of crimes which will be enhanced. It is argued that the accused number one are in judicial custody. This is not in dispute. However, the settled position of law that incarceration is not in a ground to grant bail. Further, considering what accused number one to have been indulged in illegal gratification, termination, pregnancy by taking 115 was not entered.
Yes, such specific observations were made.
But this, according to this charge sheet allegation, the amount is received by the accused number three, madam, the 15,000. Column number
Misuse
70.
ಆಗಿ
It's received by the accused number three, and the tablet
is
is
active
given.
involvement by this petitioner
The
in MTP.
in this particular A3 is enlarged on bail, madam. Page 298. madam. And A8 and A11, they are also not the same allegation, but they are also
No, only allegation accused number three is that she has given a pill and that.
bill and they collected the amount.
Aste.
Aste.
MTP is by this petitioner and his wife, accused number one.
Bill not is he is he have called this victim from the lodge and they have taken her to this manor. There is only allegation.
Assisted under Mathin. Assisted in bringing her to the lodge.
Lodge.
Aste.
Aste.
Is it?
Yes, my lord, that is the allegation.
Covered. Criminal antecedents.
No, madam. No antecedent.
Petitioner being accused number two is seeking grant of bail. He was apprehended on 6/5/2024. Since then, he is in judicial. On the basis of the first information lodged. Crime number 102 of 2024. Of respondent police was registered for the opposite offenses. Accused number one was working as
D group employee.
in
D
the
group.
government hospital,
Government.
district hospital,
District hospital.
Mandya.
Mandya.
Was working as a D group employee in district hospital, Mandya, and was staying in the government quarters. Misusing her acquaintance with the government district hospital and also her stay in the government guest house. The government quarters. She actively involved in commission of the offense of medically terminating the pregnancy of various innocent pregnant women. This petitioner is the husband of accused number one, was actively assisting her as per the charge sheet. It was this petitioner who brought CW2 to the lodge at the instance of accused number one for the purpose of conducting MTP. It is stated that accused number three is the mother-in-law of accused number one and the mother of the present petitioner. And she had given a bill to the victim, CW2, and had collected the amount. Therefore, it is clear that the entire family is involved in this act of illegal termination of pregnancy. It is brought to the notice of the court that accused number three, who has also played her role in commission of offense, is already enlarged on bail by the trial court with a order dated 13/9/2024. Therefore, the petitioner is seeking grant of bail on parity. On perusal of the statement of the victim CW2 and also the charge sheet, column number 17 of the charge sheet. The role played by the present petitioner is restricted to bringing the victim to the lodge at the instance of accused number 1. More importantly, he is the husband of accused number 1 and the son of accused number 3. Even though the role played by the petitioner is of serious nature, in view of the fact that accused number 3 is already enlarged on bail, I am of the opinion that he may be granted the benefit of parity with that of accused number 3. It is not the contention of the prosecution that the petitioner is required for further investigation or for any other purpose, except to ensure his presence before the trial court. It is also not the contention of the prosecution that the petitioner is having any criminal antecedents. The such circumstances are not allowed subject to conditions.
Serial number 10, Chandrasekhar.
But the alleged offenses will not
Petitioner is
A2.
in all how many accused? In all how many accused are there?
There are 4. For A1, my lord, your lordship has granted the bail in the month of June itself.
What about 3 and 4?
3 and 4, my lord, 4 granted the anticipatory bail and
3,
3 he did not.
he is in custody.
He is in custody.
When he was arrested, petitioner,
Lord, 23/9/2020, sorry, 29/8/2024.
what is the offense?
There are 324, 307, 504, 505, 506, read with 34.
Charge sheet is filed.
Charge sheet is filed in the month of March itself. After considering the charge sheet, my lord, your lordship has granted the bail to the A1. There is no specific allegation. The only allegation is ನಾನು ಜೇಬ್ನಲ್ಲಿರೋ ಚಾಕುನ ಅವನ ಕೈಲಿ ಕೊಟ್ಟೆ ಅನ್ನೋದಷ್ಟೇ. Lordship may kindly see, my lord.
Come to page
Page
23, column number 17.
May I read, madam?
Yes.
ಘನ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ ರಾಜನಕುಂಟೆ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಯಲಹಂಕ ತಾಲೂಕು ಹೆಸರುಘಟ್ಟ ಹೋಬಳಿ ಮಾರಸಂದ್ರ ಗ್ರಾಮದ SMS ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಪಕ್ಕದಲ್ಲಿರುವ ಅಮ್ಮ ನಾಟಿ ಸ್ಟೈಲ್ ಹೋಟೆಲ್ ಮುಂಭಾಗ ದಿನಾಂಕ 3/1/2024 ಸಂಜೆ 7:30 ಗಂಟೆಗೆ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯ ಕಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ಕಂಡ ಆರೋಪಿಗಳಾದ A1, A2, A3 ಮತ್ತು A4 ಎಂಬುವರು ಊಟದ ಬಿಲ್ ಕೊಡುವ ವಿಚಾರದಲ್ಲಿ ಹೋಟೆಲ್ ಮಾಲೀಕರಾದ ಸಾಕ್ಷಿ 6 ಮತ್ತು ಸಾಕ್ಷಿ 7 ರವರ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದಾಗ ಸಾಕ್ಷಿ 1, ಸಾಕ್ಷಿ 2 ಮತ್ತು ಸಾಕ್ಷಿ 3 ರವರುಗಳು ಹೋಟೆಲ್ ಬಳಿ ಬಂದು ಸಾಕ್ಷಿ 1 ಮತ್ತು ಸಾಕ್ಷಿ 2 ರವರು ಆರೋಪಿಗಳಿಗೆ ಇಂದು ನಮ್ಮ ಅಕ್ಕನ ಹೋಟೆಲ್ ನೀವು ಏಕೆ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದೀರಾ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ A2 ಅವರು ಸಾಕ್ಷಿ 1, ಸಾಕ್ಷಿ 2 ರವರನ್ನು ಕುರಿತು ನೀವಾರೋ ಬೋಳಿ ಮಕ್ಕಳ ಸೊಳೆ ಮಕ್ಕಳ ನಮ್ಮನ್ನು ಕೇಳೋಕೆ ಎಂದು ಅವಿಯಾಚಕ ಶಬ್ದಗಳಿಂದ ಬೈದು ಸಾಕ್ಷಿ 1 ಮತ್ತು ಸಾಕ್ಷಿ 2 ರವರನ್ನು ಸಾಯಿಸುವ ಉದ್ದೇಶದಿಂದ ತನ್ನ ಪ್ಯಾಂಟ್ ಜೇಬಿನಲ್ಲಿದ್ದ ಚಾಕುವನ್ನು ತೆಗೆದು A1 ರವರ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಇವರಿಗೆ ನಾವು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಇವರನ್ನು ಬಿಡಬೇಡ, ಇವರಿಗೆ ಒಂದು ಗತಿ ಕಾಣಿಸು ಎಂದು ತಿಳಿಸಿದ್ದು A1 ಆರೋಪಿಯು ಚಾಕುವಿನಿಂದ ಸಾಕ್ಷಿ 2 ರವರ ತಲೆಗೆ ಹಾಗೂ ಎಡಗೈಗೆ ಮತ್ತು ಸಾಕ್ಷಿ 1 ರವರ ಎಡಪಕ್ಕೆಗೆ ತಿವಿದು ರಕ್ತ ಗಾಯಪಡಿಸಿದ್ದು A4 ರವರು ಒಂದು ಖಾಲಿ ಬಿಯರ್ ಬಾಟಲ್ ತೆಗೆದುಕೊಂಡು ಬಂದು ಸಾಕ್ಷಿ 2 ಅವರ ತಲೆಗೆ ಹೊಡೆದು ರಕ್ತ ಗಾಯಪಡಿಸಿ A2 ಮತ್ತು A3 ಎಂಬುವರಿಗೆ ಇವರನ್ನು ಉಳಿಸಬೇಡ, ಬಾಟಲ್ನಿಂದ ಚುಚ್ಚಿ ಸಾಯಿಸು ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿದ್ದು. ಆಗ A3 ಅವರು A4 ರವರ ಕೈಯಲ್ಲಿದ್ದ ಬಿಯರ್ ಬಾಟಲ್ ಕಿತ್ತುಕೊಂಡು ಬಿಯರ್ ಬಾಟಲ್ನಿಂದ ಸಾಕ್ಷಿ 1 ಹಾಗೂ ಸಾಕ್ಷಿ 2 ತಲೆ ಹಾಗೂ ಮೈ ಕೈಗೆ ಹೊಡೆದು ಗಾಯಪಡಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸುತ್ತಿದ್ದಾಗ ಇದುವರೆಗೂ ನಡೆಯದ ತನಿಖೆಯಿಂದ ಆರೋಪಿಗಳ ವಿರುದ್ಧ ಆರೋಪವು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. Last may kindly take the wound certificate. Page
There are two
60.
injured, CW1 and 2.
Pardon?
2 injured are there.
Huh?
There are 2 injured persons.
There were 2 injured persons, but the entire charge sheet and the complaint is against there were only 1 injured. Lord, page number 60, your lordship kindly. Wound certificate. Typed copy, my lord, page 61.
Yes, what is it? Really, there 3 ಕೊಟ್ಟಿದ್ದು. Have you produced the order
Your lordship.
granting
Yes,
bail to accused number 1?
yes,
Where is it?
Lord, page 80.
Huh?
Page 80, by your lordship, my lord. Page 80.
Antarika.
My lord, petitioner is a rowdy sheeter, my lord. There are 4 cases against him in the same police station, my lord, for the offences and section 324, 302 and different offences. My lord.
Yes. Rowdy sheet.
It was absconding, my lord, till the charge sheet was
Lord,
filed, my lord. And on 29/8/2024, my lord, he was arrested.
After filing the charge sheet.
Yes, my lord. Charge sheet was filed on 7/3/2024, my lord. He was arrested on 29/8/2024. Till then, he was absconding, my lord.
Lord, there is no incident, he is not a rowdy sheeter. My lord, otherwise, my lord, in the charge sheet, they could have
Produce the
stated,
document.
in the charge sheet, they could have stated in the charge sheet.
You produce the document.
I'll produce the FIR copy.
And also the fact that you are not, you are absconding when the charge sheet is filed.
Yes, my lord.
When will you produce?
Sixth of November, my lord.
Third learned counsel for the petitioner and learned HCP. Learned HCP submits that the petitioner is a rowdy sheeter. And the said fact is disputed by the petitioner, counsel for the petitioner. HCP takes for time to produce the document in support of her contention. List down. When?
6th of November.
6th.
Serial number 11, Sanjay BK.
Why you have not produced the certificate copy?
Lord, I'm producing it now.
Counsel for the petitioner submits that was producing the certificate copy of the impugned order and bail rejection order passed by the trial court. Hence, IA 1 of 2024 filed for seeking dispensation, producing the certificate copy is dismissed.
Lower court order, PP objections.
Yes.
Please, my lord. This is a petition under section 482,
BNSS, my lord, for the relief of anticipatory bail. A FIR came to be registered in crime number 33 of 2024 on 15/3/2024, my lord, for the offences punishable under section 354B, 506, 504, 34, read with section 67, subclause A, IT Act, my lord.
In all, how many accused?
In all, there are 3 accused, my lord. Accused number 2 and 3 are the petitioners in this petition.
2 and 3.
2 and 3, my lord.
What about 1?
1 has not filed this petition, my lord. No, basically the entire,
The accused were apprehended.
none of them have been apprehended. 67. My respectful submission, my lord, is
Yes.
the complainant before police is known to accused number 1. They have had some sort of a interaction over a period of about 8 months, my lord. Apparently, as per the, though it is not true, as per the averments made in the complaint,
Complainant is the victim.
complainant is supposedly the victim, my lord.
Hmm.
Now, to say victim, my lord, I would like to draw my lord's kind attention to section 354B, my lord. 354B. My lord, if I may be allowed to read 354B. Assault or use of criminal force to woman with intent to disrobe. Any man, it says any man who assaults or uses criminal force to any woman or abets such act with the intention of disrobing or compelling her to be naked shall be punished with an imprisonment of whatever. My respectful submission, my lord, the petitioner, the first petitioner is a lady in this case, my lord. Now, at any length of imagination, even assuming that we bring in section 34, that she's been at the spot when all these alleged acts have been committed, it is beyond my imagination, my lord. Any woman would go to that extent, allowing her husband to make allegations of disrobing the other person, my lord.
It is anything is possible,
That
sir.
my most humble submission before my lord. It happens only in movies, my lord. I have not seen these things happening
You
where
might
a
not have
wife,
seen. You might not have seen.
my lord is right.
Yes.
My lord is well aware of all these situations, my lord. Now I would like to draw my lord's kind attention to the complaint itself, my lord. Now, the complaint which was submitted by the supposed victim was something else. It was changed in the police station. By looking at page 29, my lord. 28 is the written complaint. My lord may kindly take page 28, my lord. 24 is the FIR, certified copy of the FIR.
The name of accused number 1?
Padmamma, my lord. Accused number 1 is Murthy, my lord.
Who is Vasu Venkatesh?
Venkatesh is me, my lord, the third petitioner. Padmamma is my wife, my lord. Now, on perusal, my lord, of 28, it has been drafted, written by the police themselves. I would not at this stage say that there is anything wrong with that. My lord may kindly turn to page 30, which is the typed copy of the written complaint, my lord. If I may be allowed to read, my lord.
1 minute.
Yes, such a.
Yes.
My lord. Page 30, my lord. That's the typed copy of the written complaint, my lord. ರವರಿಗೆ ಚನ್ನರಾಯಪಟ್ಟಣ ಪೊಲೀಸ್ ಠಾಣೆಯ ಆರಕ್ಷಕ ನಿರೀಕ್ಷಕರ ಸಾಹೇಬರ ಸನ್ನಿಧಾನಕ್ಕೆ ಸ್ವಾಮಿ, ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಚನ್ನರಾಯಪಟ್ಟಣ ಹೋಬಳಿ ಕೊನೆಗಿನೆ ಬೆಲೆ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಸುಮಾರು 28 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ಪಲ್ಲವಿ
ಡಾಟರ್ ಆಫ್ ಮುನಿನಾರಾಯಣಪ್ಪ ಎಂಬ ನಾನು ಬರೆದುಕೊಡುವುದೇನೆಂದರೆ, ನಾನು ಕೊನಗಿನ ಬೆಲೆ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ನಮ್ಮ ಜಮೀನಿನ ಕಾಗದ ಪತ್ರಗಳನ್ನು ಹುಡುಕಿಸಿ ಕೊಟ್ಟು ನನಗೆ ನಮ್ಮ ಜಮೀನಿನ ಮಾರಾಟ ಜಮೀನಿನ ಹಕ್ಕು ಕೊಡಿಸಿಕೊಡುವುದಾಗಿ ನಾಗನಹಳ್ಳಿಯ ಗ್ರಾಮದ ವಾಸಿಯಾದ ವೆಂಕಟೇಶ್ ಬಿನ್ ಮುನಿಯಪ್ಪ, ಮೂರ್ತಿ ಬಿನ್ ಲೇಟ್ ಬೈಯಪ್ಪ ಎಂಬುವರು ನನ್ನನ್ನು ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಓಡಾಡಿಸಿಕೊಂಡು ನನ್ನನ್ನು ಲೈಂಗಿಕವಾಗಿ ಬಳಸಿಕೊಂಡು ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ನಮ್ಮ ಜಮೀನನ್ನು ಬೇರೆಯವರಿಗೆ 90 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಮಾತನಾಡಿಸಿಕೊಂಡು ನನಗೆ ಕೊಡಿಸುತ್ತೇನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳಿಕೊಂಡು ನನ್ನನ್ನು ನಾಗನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿರುವ ಈ ಮೇಲ್ಕಂಡ ವೆಂಕಟೇಶ್ ಮನೆಗೆ ಕರೆಸಿಕೊಂಡು ಮೂರ್ತಿರವರನ್ನು ಹೇಳಿದಂತೆ ನಾನು ಕೇಳದಿದ್ದರೆ ನನ್ನ ನಗ್ನ ಫೋಟೋಗಳನ್ನು ಎಲ್ಲಾ ಕಡೆ ಅಂಟಿಸುವುದಾಗಿ ನನಗೆ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನಾನು ಒಬ್ಬಳೇ ಓಡಾಡುವಾಗ ನನ್ನ ಮೇಲೆ ಆಸಿಡ್ ಹಾಕುವುದಾಗಿ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ತಿಳಿಸುವುದೇನೆಂದರೆ, ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ಪತ್ನಿಯಾದ ಪದ್ಮಮ್ಮ, she has not interacted with me till today, she has not seen me till today, my lord, as far as the first petitioner is concerned, ಎಂಬುವರು ನನಗೆ ಭಾರಿ ಕಿರುಕುಳ ನೀಡಿರುತ್ತಾರೆ. ವೆಂಕಟೇಶ್ ಅವರ ಪತ್ನಿಯಾದ ಪಲ್ಲವಿ ತುಂಬಾ ಕೆಟ್ಟ ಶಬ್ದಗಳಿಂದ ಬೈದಿದ್ದು, ಸ್ವಾಮಿ, ಈ ಸದರಿಯವರ ಈ ರೀತಿ ಕಿರುಕುಳದಿಂದ ನಾನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರಲು ಓಡಾಡಲು ಭಯವಾಗಿರುತ್ತದೆ ಎಂಬುದು ತಾಲೂಕು ಕಚೇರಿಯಲ್ಲಿ ರೆಕಾರ್ಡ್ ರೂಮಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ನನಗೆ ಇಲ್ಲ ಸಲ್ಲದ ಅಂಶಗಳನ್ನು ಒಡ್ಡಿ ನನ್ನನ್ನು ಎಲ್ಲಾ ರೀತಿಯಲ್ಲೂ ಬಳಸಿಕೊಂಡು ಈಗ ನನಗೆ ಈ ರೀತಿ ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ರವರು ಅವರ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆದ್ದರಿಂದ ಕಾವಂದರು ಈ ಬಗ್ಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ತಿಳಿಸುವುದೇನೆಂದರೆ, ವೆಂಕಟೇಶ್ ಮತ್ತು ಮೂರ್ತಿ ಮತ್ತು ಪದ್ಮಮ್ಮ ಎಂಬುವರ ಮೇಲೆ ಈ ಬಗ್ಗೆ ಕ್ರಮ ತೆಗೆದುಕೊಂಡು, ಹಾಗೂ ನಾನು ಮೇಕಪ್ ವಿಷಯಕ್ಕೆ ಮೈಸೂರು ಮತ್ತು ಹುಬ್ಬಳ್ಳಿಗೆ ಹೋದಾಗ ಅಲ್ಲಿ ರೂಮ್ 2 ಮಾಡಿದೆವು. ಮೇಕಪ್ ಮುಗಿಸಿ ನನ್ನ ಮೇಲೆ ಕಿರುಕುಳ ಕೊಟ್ಟಿದ್ದಲ್ಲದೆ ಮತ್ತೆ ಅಲ್ಲಿಂದ ಮನೆಗೆ ಬಂದಾಗ ಮತ್ತೆ ಮೂರ್ತಿಯವರು ಕಾಲ್ ಮಾಡಿ ಮನೆಗೆ ಬನ್ನಿ, ಫೋನ್ ನಂಬರ್ ವಾಟ್ ಸೋ ಅಂಡ್ ಸೋ ಎಂದು ಹೇಳಿ ವೆಂಕಟೇಶ್ ಮತ್ತು ಮೂರ್ತಿಯವರು ನಾನು ಹೇಳಿದ ಹಾಗೆ ಕೇಳಲಿಲ್ಲ, ಫೋಟೋಗಳನ್ನು ಕಳುಹಿಸಿ ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡಿರುತ್ತಾರೆ. ಮೂರ್ತಿಯವರು ಇವರ 3 ಜನರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಬೇಕಾಗಿ ಈಗ ತಡವಾಗಿ ಕೊಡುವ ಕಾರಣ ಏನೆಂದರೆ, ನನ್ನ ಫೋಟೋಗಳನ್ನು ಮೂರ್ತಿ ಮತ್ತು ವೆಂಕಟೇಶ್ ಇನ್ಸ್ಟಾಗೆ ಹಾಕುತ್ತೇನೆಂದು ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನನ್ನ ಮತ್ತು ನನ್ನ ಮಕ್ಕಳಿಗೆ ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿದ್ದರಿಂದ ಈ ದಿನ ದೂರು ನೀಡಲು ತಡವಾಯಿತು. ಇಂತಿ ತಮ್ಮ ಆಕಾಂಕ್ಷೆ. My respectful submission, my lord. On a bare perusal of this complaint, my lord, the dates, the time, nothing is forthcoming. Now, there should be some proximity of the offense committed and the FIR registered, my lord. Now, she says she is having some sort of a relationship with accused number 1 starting June 2023. The complaint comes to be registered on February 15, 2024, my lord. Now, I would like to draw my lord's kind attention to the objections filed by the learned PP, my lord, which I have furnished before, my lords, just now, my lord. It is at page 8, my lord, 8 and 9. Objections filed by the PP.
Yes.
Certain things are forthcoming in that, my lord. My lord, it is in page 9, if I may be allowed to read. ಪ್ರಕರಣದಲ್ಲಿ ಪೊಲೀಸರು ತನಿಖೆಯನ್ನು ಕೈಗೊಂಡು ದಿನಾಂಕ 18/3/2024 ಮತ್ತು ದಿನಾಂಕ 19/3/2024 ಪಲ್ಲವಿರವರನ್ನು ವಿಜಯಪುರ ಮತ್ತು ದೇವನಹಳ್ಳಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷೆಗೆ ಒಳಪಡಿಸಿ ವರದಿ ಪಡೆದುಕೊಂಡಿದ್ದು, ಸದರಿ ವರದಿಯಲ್ಲಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಎಸಗಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಕುರುಹುಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಎಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ. That's what the PP says, my lord. Now the next paragraph. ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದಿ ಪಲ್ಲವಿರವರಿಗೆ ದೂರಿನಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಆರೋಪಿಗಳು ನಿಮ್ಮ ಮೇಲೆ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಎಸಗಿದ ಸ್ಥಳಗಳನ್ನೆಲ್ಲ ಮೈಸೂರು, ಊಟಿ, ಇತರ ಸ್ಥಳಗಳಲ್ಲಿ ತೋರಿಸುವಂತೆ ಆರೋಪಿಗಳು ತಮ್ಮ ಖಾಸಗಿ ಚಿತ್ರಗಳನ್ನು ಕಳುಹಿಸಿ ಅವುಗಳನ್ನು ಸಾಮಾಜಿಕ ಜಾಲತಾಣಗಳಲ್ಲಿ ಹಾಕುವುದಾಗಿ ಬೆದರಿಸಿರುತ್ತಾರೆಂದು ತಿಳಿಸಿದ್ದು, ಆರೋಪಿಗಳು ನಿಮಗೆ ಕಳುಹಿಸಿರುವ ಚಿತ್ರಗಳ ಮಾಹಿತಿಗಳನ್ನು ಹಾಗೂ ನಿಮಗೆ ಕಳುಹಿಸುವ ಮೊಬೈಲ್ ಫೋನ್ ನನ್ನು ತನಿಖೆಗೆ ಬಗ್ಗೆ ಹಾಜರು ಪಡಿಸುವಂತೆ ಆರೋಪಿಗಳು ತಮ್ಮೊಂದಿಗೆ ಸಂಪರ್ಕದಲ್ಲಿದ್ದ ಮೊಬೈಲ್ ನಂಬರ್ಗಳ ವಿವರಗಳನ್ನು ನೀಡುವಂತೆ ಆರೋಪಿಗಳನ್ನು ತಮಗೆ ಸೇರಿದ ಯಾವ ಜಮೀನಿನ ದಾಖಲೆಗಳನ್ನು ಮಾಡಿಸಿಕೊಂಡಿರುವುದಾಗಿ ಹಾಗೂ ಮಾರಾಟ ಮಾಡಿಸುವುದಾಗಿ ತಿಳಿಸಿದ ಜಮೀನಿನ ದಾಖಲೆಯನ್ನು ನೀಡುವಂತೆ ಆರೋಪಿಗಳು ತಮಗೆ ತೊಂದರೆ ನೀಡಿ ಬೈದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿದ ಸಮಯದಲ್ಲಿ ಹಾಜರಿದ್ದ ಸಾಕ್ಷಿದಾರರ ಮಾಹಿತಿಗಳನ್ನು ನೀಡುವಂತೆ ಮತ್ತು ಮೈಸೂರು ಮತ್ತು ಊಟಿ ಸ್ಥಳಗಳ ಮೇಕಪ್ ಮಾಡಲು ಯಾವ ಯಾವ ದಿನಾಂಕವನ್ನು ತೆರಳಿರುತ್ತೀರಿ ಹಾಗೂ ತಮ್ಮೊಂದಿಗೆ ಬಂದಿದ್ದವರ ವಿವರಗಳನ್ನು ನೀಡುವಂತೆ ದಿನಾಂಕ 13/3/2024 ಮತ್ತು ದಿನಾಂಕ 17/3/24 2 ಬಾರಿ ಪೊಲೀಸರು ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಿದ್ದು ದಾಖಲೆಗಳನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. My lord, everything is an absolute falsehood. My respectful submission is the complainant before police, my lord, takes a loan of about 15 lakhs from accused number 1. Now she's been having apparently a jolly good time with him over a period of time. Now at the time of repayment, my lord, this is the practice that she goes before the police, she lodges a complaint. The police inspector, my lord, changes the entire complaint, implicates me and my husband, my lord, and a FIR comes to be registered. The dates are conspicuously missing, the time is conspicuously missing, my lord. My doors are locked since 15/3/2024, my lord. Everything is lost for me, my lord. I'm a housewife. I have not gone out of my house. Nala Deepavali, I'm still struggling to get a bail. This is where I stand, my lord. None of the offenses alleged, my lord, are punishable with death or imprisonment for life, my lord. My most respectful submission is I am prepared to abide by any condition that this honorable court would deem fit to impose upon me. I would also cooperate with the investigating officer, my lord. I would surrender before the IO. Let him be directed to release me on anticipatory bail, my lord.
The complaint, my lord, there are allegations made against petition number 1 and 2, my lord. And my lord, the 164 statement of the victim is also been recorded, my lord. And that has not been produced, my lord, and the objection was filed in the month of March, my lord. At that time, my lord, investigation was still pending and she has not yet furnished the details, my lord.
What was the necessity to say all those things? When he has stated means there must be some seriousness. Was it required on the part of the prosecution?
Was not required.
Then he is entitled to take advantage. Petitioners being accused number 3 and 2 respectively are seeking grant of bail. Reasons. Petitioners being accused number 2 and 3 are seeking grant of bail, 3 and 2 respectively are seeking grant of bail on the apprehension of being arrested. The victim, who is aged 28 years, filed the first information to the police on 15/3/2024, alleging commission of offence by accused number 1 to 3 from 1/6/2023 till 15/2/2024. It is alleged that he is sexually misused by accused number 1 and 2, taken her nude photos, threatening to share the same in the social media, and also threatening to throw acid if she does not heed to their demands. Petition number 1 oblique accused number 3 is a woman and she is the wife of petition number 2 accused number 3. My attention was drawn by the learned counsel for the petitioner to the statement of objections filed by the learned public prosecutor before the trial court, when the petitioner has sought for grant of anticipatory bail, wherein the prosecutor has specifically stated that the victim has not shown the places where the offense was committed. The victim has not assisted the investigating officer during investigation by showing the place where the offense was committed. Nor she has provided the phone numbers of the accused to which she used to contact them. She has not provided the phone mobile handsets used while the accused committed the offense. Nor she has stated about the persons who were knowing about the commission of the offense by the accused. And counsel for the petitioner has also referred to the medical records to contend that even after a medical examination of the victim, there was no evidence of sexual assault committed on the victim as contended in the first information. Yes. Time of receipt is seen that the victim has not given the date and the time of committing the offense. If all these facts and circumstances are taken into consideration, I am of the opinion that the petitioners may be granted and expected, subject to conditions which will take care of so much. Yes. Allowed subject to conditions.
For part or matter. Serial number 1, Malana Gowda. List 4, serial 1, Malana Gowda.
Yes.
Lord, this is the matter which I had mentioned yesterday. Lord, the complainant is a mutt called some Chandramoleshwara mutt.
There are office objections to be complied. First you have to comply, sir.
Office of concern.
Everything there cannot be ignored.
Lord, the main office objection is certified copy. For now, we have produced a photocopy. We'll.
Why certified copy is not available?
Petitioner not attended to the PCR. Is referred for investigation.
That cannot be the ground. When there is urgency, you should be very prompt in complying the office objections.
Lord, that certified copy will furnish Lord, till Monday. Lord, they need some protection because there's a long gap now. Lord, I have a prima facie case. Lord, on the certified copy. Lord,
there is a long weekend holiday, and according to you, there is urgency. He should be very prompt in complying the office objections.
Lord, we'll comply. We'll comply with that. By
cannot take your own advantage of your own wrong.
No, my Lord. Lord, we will comply. Lord, every single office objection will be complied. Lord,
counsel for the petitioner is seeking time to produce the certificate copy, so interim protection is granted.
Adala, my Lord, this is a truthful copy of the certified copy. My Lord, I can vouch at your Lordship's bar. My Lord, certified copy we will furnish. My Lord, till then, my Lord, Lordship may grant me some time to produce the certified copy. In view of the, my Lord,
what is the, how many objections are there? One certificate copy. Many objections. How many? In all, 10 office objections are raised. You are not bothered to look at the order sheet. Only say urgency in the matter. Give the protection. That is the only submission. Who has to comply?
Lord, Lord, may make this submission. Lord, my Lord, will comply with the office objection, but none of these office objection are material. I can say that, my Lord.
Even then,
Lord,
even then, why it is weak?
Lord, if they were material, my Lord, I would not,
Sir, with some purpose, the office is directed to follow certain.
Lord, I follow that. I follow that.
Then.
Yesterday, Lord, I mentioned there was the file had to be sent.
I am finding fault with the counsel on record.
Lord, I'll guide him. Lord, he will do it. In view of the urgency, I had to mention.
Guiding, he knows it, but chalta hai.
No, it is not a case of indifference, my Lord. Particularly this colleague, I am aware.
I don't know.
He would not do it.
So, file ತೋರಿಸಲೇ ಇಲ್ಲ in fact.
Not a typed copy there. ಅಷ್ಟು ನೀವು ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಮಾಡಿದ್ರೆ ಹೇಗೆ ಸರ್?
Lord,
At the 11th hour you file the petition and our neck ಮೇಲೆ ಕೂತ್ಕೊಳ್ತೀರಿ, head ಮೇಲೆ ಕೂತ್ಕೊಳ್ತೀರಿ. I know the difficulty of the officials, how they are working.
Lord, the issue here is,
Hmm.
The complainant had filed a suit. My Lord, would your lordship kindly have a look at page 23, annexure D.
Who is the petitioner?
The petitioners are two employees of the railways.
Accused number 1 and 2.
Yes, accused number 1 and 2.
How many accused are there?
Totally there are 5. Totally there are 5.
What are the offenses?
I'm sorry, what?
What are the offense?
Offense, my lord, mainly it is trespass, and then a whole lot of other offenses like snatching, breaking open a receptacle are added. But my lord, the main, if we go by the statements made in the complaint, it is trespass on the ground that there was a injunction by the civil court. My lord, that injunction order your lordship will find at page number 23. May I take your lordship first through what was the order passed by the court until when it continued, then my lord, I'll take you to lordship to the statements in the complaint.
Sir, where is the FIR, sir? What is the allegation, basic allegation?
There is no, my lord, this is a PCR.
Huh? PCR.
This is a PCR. That your lordship will find at page 12, annexure B. The relevant allegations are at page 15, para 8. Page 15, para 8. It is submitted that the accused railway employees are again and again trespasses the property of the complainant by ignoring the interim order granted by the Honorable City Civil Court in OS number 2251 of 2018. On 2/8/2024, they have trespassed the property of the complainant by violating and disrespecting the interim order and abusing the advocate as well as the judge. In that regard, the complainant given the complaint before Upparpet police station, but the police inspector have received the complaint by 6:30 PM on 2/8, but he has not registered the complaint and asked this police to give NCR. NCR copy is hereby produced. Complainant also lodged a complaint before Commissioner of Police on 6/8. So far, no action has been taken, hence there is no alternative. And then, Lord, he is making, this is the crux of the allegation made, there is no other allegation made. Now, my lord, would your lordship have a look at the nature of injunction granted? Because that forms the basis of the allegation. That order of injunction begins at page number 23. The order sheet begins at page 23. And if you look at the relief sought at in the order sheet, whatever is in the bold capitalized writing.
Page number?
Page number 23. Page number 23, annexure D. Only relief has been extracted. Prays to pass a judgment and decree in favor of the plaintiff against the defendant in granting decree of permanent injunction against the defendant and their henchman, servant, supporter in restraining them from interfering with peaceful possession and enjoyment of the property.
This is the suit filed by the complainant.
Yes, suit filed by the complainant. It was heard on the very same day of filing, that is 24/3/2018, and the Honorable Civil Court was pleased to grant an ex parte TI. That is available at page 24. Page 24, I'll read from the middle para. Heard and perused all papers. Prima facie case is made out. Thus, ad interim temporary injunction is granted, restraining the defendant and their persons from interfering with peaceful possession of the plain scheduled property till next date of hearing. Plaintiff is directed to comply with the mandatory provisions of 39 Rule 3. Issue summons, emergent notice and warrant of TI against defendants returnable by 8/6. Then 10 days later, an IA is filed by an impleading applicant. He advances the matter to 4/4/2018. And the order reads as, Learned Counsel for the impleading applicant, Sri Ramachandra Swami, has filed this advancement application to prepone the case from 8/6/2018 to this day, and another IA under Order 10 Rule 2 to implead him as second defendant along with wakalat and list of documents. It is submitted that already a suit in OS number so-and-so is filed and pending before CCH2. However, the suit is filed by a dead person as the plaintiff is died on 28/9/2014. Copies of IS are sent through speed post to the counsel for plaintiff, but in spite of it, the plaintiff is not represented. Thus, call on for objection on 9/4. Lordship will notice that there is no continuation of the TI granted. Now, there is no continuation till date. Finally, and now, page number 52, an IA has been filed for extension of the TI. Page number 42, if your lordship will see, the order sheet dated 19/9/2024. In that, somewhere in the middle, page number 52,
1 minute, 1 minute.
page 52, order sheet dated 19/9/2024. In the center, advocate for plaintiff filed IA number 10. Page 52.
Yes.
IA in the center. Advocate for plaintiff filed IA number 10 under section 151 for extension of TI. And at the bottom, call on so and so for cross-examination and objection to IA number 10, which means that with effect from 4/4/2018, there was no TI. Without verifying all these facts, the learned magistrate proceeds to hold the issue summons and issue directions to the police to investigate.
The date of offense is 24/7/2024 and 2/8/2024.
Yes. On which from 4/4/2018, there is no injunction. They are not even attending the proceedings. Once in a while, they come.
I responded. First, comply with the office objections. Don't be under the impression the order will be released. On IA 1 of 2024. Reviews the materials on record. Prima facie it is satisfied that the interim order of temporary injunction granted by the trial court in OS 12-2251 of 2018 with an order dated 24/3/2018 till next date of hearing, that is till 8/6/2018. What is not extended further. Full stop. The application IA 10 under section 151 of CPC was filed before the trial court seeking extension of the interim order only on 19/9/2024, which is said to be pending for consideration. Next para. As per the allegations made in the complaint, the accused have trespassed over the property of the complainant on 24/7/2024 and on 2/8/2024 and committed the offense. It is stated that such trespass was in violation of the interim order granted by the trial court. But prima facie, there was no such interim order which was in operation as on those days. Hence, what is the interim protection you wanted? What is the interim protection?
Lord, there is apprehension of arrest.
Bail and Kelilwa, you have not approved the court for bail?
No, my lord, not yet.
Okay.
Not yet. We have sought for stay of further proceedings.
The order is dated. Order.
Lord,
156.3.
Lord, just page number 10.
Four nine
4/9.
24. 4/9 ಇಂದ ಇವತ್ತಿನವರೆಗೂ ಬೇಲ್ ಕೇಳಿಲ್ವಾ?
ಅಲ್ಲ ಇವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ ಅವರ. As soon as they came to know about it, my lord, they have approached this on court. Having realized, my lord, that there is a prima facie case and it's an abuse of the process of law. But when they came to know about these proceedings, my lord, they approached your lordship.
Maybe, but the first steps that generally the accused will take to move a bail application. Either anticipatory or being.
True, my lord, but since there was a.
Of late, procedure is adopted, file 482 and get all the relief under one petition without moving the application for bail. I am not for that.
No, since my lord, the primarily the allegation against
The object of
the railway
this petition
department.
is entirely different.
My lord,
Object is entirely different.
my lord, as your lordships have seen, the complainant, my lord, is a clear, if your lordships look at the list of offences that he has alleged, it's a clear abuse of the process of law. It's like harassing the public servants who are discharging their duties.
This. Hence, there shall be an interim order of stay for the. Registered against the petitioner till next date of hearing. Subject to the condition that the petitioner shall comply with the office objections forthwith. If the office objections are complied with, issue notice. Yes. This order is subject to compliance of office objections.
I'm grateful to yours, my lord, we'll comply with forth. Grateful.
Next.
We passed our matter, serial number 6, Sunil S. Narayan, Virupakshaya.
Lord, I'm sorry. Lord, serial number 15 in list number 1, I believe the central government is, once again, railways is involved in a criminal appeal. Lord, I believe earlier, railways had their own panel. Now it comes to the office of ASG. So the old council cannot continue. I will do a fresh nomination. Lordship may call it after.
There is no panel of advocates.
Now there is no, railway does not have a panel. It comes to ASG now. It's all comes in our fold now.
Then what is to be
The
done?
central government council, but I'll do a fresh nomination. My colleague Malan Gaud will appear. Lordship may call it after 2 weeks. But a week later, Lord, we'll secure the records and Malan Gaud will get ready.
I will not accept this memo till then. Memo for retirement.
Lord, no, they are the old panel council. They have now no right to continue.
Then who will represent the
Lord,
petitioner?
my office, my lord, office of ASG will represent. I will nominate some.
Record your submission.
Yes, please record. That's my submission.
So submit that. Learned Counsel Sri Narayan Swami VK is no more on the panel of the appellant. And the procedure for empaneling the advocates is on and therefore prays for 2 weeks' time. Submission is placed on record. In view of the above, memo for retirement filed by so and so is accepted. He is permitted to retire from the case. Appellant to represent by an advocate, list on. 2 weeks. Yes.
I'm grateful to you.
History, serial number 6, Sunil S. Narayan, Virupakshaya.
Petitioner.
Medical records.
Start for medical.
Serial number?
Central jail in Bangalore, madam. Central jail Bangalore, they have not yet sent the medical report.
AK.
ಬರೀ ಔಟ್ ಪೇಷಂಟ್ ಆಫ್ ದಾವಣಗೆರೆ ಹಾಸ್ಪಿಟಲ್ ಬಂದಿದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲೂ ಕೂಡ ಅದರಲ್ಲಿ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಮೆಮೋ ದಟ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಶೀಟ್ ಸೇಮ್ ಥಿಂಗ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
1 month ಇಂದ ಅವ್ರಿಗೆ ವಾಮಿಟಿಂಗ್ ಅಂತ ಬ್ಲಡ್ ವಾಮಿಟಿಂಗ್ ಅಂತಿದೆ, ಪ್ಲಸ್ ಆಲ್ಸೋ ಅವ್ರಿಗೆ ಫರ್ದರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಅಂತಾನು ಬೆಂಗಳೂರಿಗೆ ಕಳಿಸ್ಬೇಕು ಫರ್ದರ್ ಟ್ರೀಟ್ಮೆಂಟ್ಗೆ ಅಂತ.
And now what is his condition ಅಂತ ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು, ವೆದರ್ his condition compels for grant of bail. ಇದು I think this is the second time ಅನ್ಸುತ್ತೆ ಬರ್ತಾ ಇದೆ. HCGP again plays for time to produce the medical records as directed to be produced as day order dated so and so. This time. When will you produce? 6th. Yes. No.
Outdoor matters. List 1, serial number 23. Needful is done. Serial number 23.
Yes. ಅದೇನು ಬೆಳಿಗ್ಗೆ ಒಂದು ಸ್ವಲ್ಪ ಹೇಳಿದ್ದೀನಿ, ಆರ್ಡರ್ ತಗೊಳ್ಳಿ. Prasanna Shetty submits that he has complied with the office objections. Is to verify. If office objections are complied with, list for orders. Next.
Serial number 27, Radha Ramesh.
In this case, my lord, we have sought the GPA copy, my lord. When you time may be granted.
ಆಯ್ತು, ಈಗ ಅಲ್ಲಿ 4 years ಆಗಿದೆ, ಇದನ್ನ ಹೇಳ್ಕೊಂತ.
ಒಂದು ಅವಕಾಶ ಕೊಡಿ ಸ್ವಾಮಿ.
ಸಾರಿ, ಫೈನಲಿ ಅಂತ ಆಗೋಗಿದೆ. Do whatever you want.
ಒಂದು ಅವಕಾಶ ಕೊಡಿ ಸ್ವಾಮಿ.
No sir, sorry, next. ಇಲ್ಲ ಹಾಗೆ
Serial number 30, Nagesh, needful is done.
Complied.
I have complied, my lord.
Submits that he has complied with the office objections. Office to verify. If office objections complied, list for orders. Yes.
32, Joshua Watson Samuel.
It was on the council submission, my lords. My submission is that the office has raised an objection saying that the petition number 1 is not a party to the charge sheet. Their name is not found in the charge sheet. My lords, it is a petition number 1 who lodged the complaint. The complaint is at page number 43.
Page number 23.
43.
43.
It is signed by.
43 ಇಲ್ಲ ಸರ್, ಬೆಳಿಗ್ಗೆನೆ ಹೇಳಿದೆ ನಾನು.
ಇಲ್ಲ, 43 is a complaint. It is a letter by hand. It is to the Inspector of Police, Vailikawal Police Station, Bangalore. That is a complaint.
This is the complaint.
Yes.
By whom?
Signed by the petition number 2, who is the president of the petition number 1 trust. Petition number 2 is the charge sheet of witness CW1.
Whether name of petition number 2 is mentioned here?
Yeah, it is there. Below AVM RK Bata is retired. In the complaint itself, at the end, yours sincerely, that sign is there.
AVM RK Bata.
Bata.
That is the only objection.
That is the only objection for which I have written, I have given an explanation.
Heard and got the petitioner on office objection at serial number 3. Peruse the annexure.
It's not annexed, it's a document, it's a complaint number 43.
Peruse the first information produced at page number 43. In the light of the first title in the petition, that is why office objection is ignored. The submission is accepted.
There is an urgency, my lord, it could be taken up 2:30 minutes because there is an urgency.
Scale-
Because the matter is there today, my lords, before the trial court.
Yes, you are representing.
Representing the accused, madam.
Huh?
I am representing the accused.
Respond number 2, my lords.
My respectful submission is, my lord, there the trial court, my lord, is represented by public prosecutor.
Hmm.
The public prosecutor, my lord, has filed an application with 311 for recall.
Hmm.
The trial court, my lord, has observed that the date
the recall has been, the application has been filed only to fill up the lacuna that has been for.
Recall whom?
Recall PW 1 to 3, my lord.
What has
We
happened is,
kindly
what has
check-
happened, my lords, the prosecution witness, prosecution, but at the time of examination, my lords, we have been permitted to assist the prosecutor. What has happened, my lords, he wrongly examined the cash sheeter witness as a master witness and master witness as a cash sheeter witness.
Even in spite of granting permission to assist the prosecutor.
No, we assisted him, he told them, but he mistook them, he examined them, because that's the issue, man.
What the assisting advocate was doing?
Not see.
Huh?
No,
Why his assistance was given to the prosecutor?
not we are.
Even after giving assistance, if this is the position,
That is a mistake, only the mistake should be.
what is the urgency in that?
Now, today there is a, it is for final arguments of the.
Argument in judgment ಆಗಲ್ಲ
No, no.
ಇಲ್ಲಿ. Unlike in high court,
No, minutes. To be-
it will take some time.
no, but they are insisting to go ahead with the today itself argument by the both the councils, madam. That's the reason.
Argument ಮಾಡಿ,
Minutes.
argument ಮಾಡಿ.
It could be at 2:30 minutes.
2:30. HGP to take notice. Huh? HGP to take note. You have filed wakalat?
Yeah, they are.
Yes, what do you say?
I request my lord to kindly take in page 41.
ಆಯ್ತು, ಆ merits ಅಲ್ಲ. ಇದು
ಇದು Monday ಹಾಕೊಳ್ಳಿ, Monday, Tuesday ಹಾಕೊಳ್ಳಿ. My lord, this the case was posted for judgment. He filed an application on the
ಇದು ನಮ್ ಕೊಟ್ಟಿದ್ದೆ.
311. That application came to be rejected. He challenged that same before the honorable court, my lord, and coordinate bench.
2:30.
Okay.
Right here. Furnish the copy to the learned HCGP.
Serial number 33, Suresh Subbaiah. ಅಷ್ಟೇನಾ?
Counsel for the petition, appellant is absent, no representation. Even when the matter is passed over twice and again called at 1:25 PM. The petition, the appeal is of the year 2018. Order sheet dated so and so, reads that in spite of that, the office objections are not complied with, even though it is listed for the 5th time. It appears the appellant is not interested in prosecuting. Appeal is dismissed. Next.
Serial number 35, MS Chandrasekhar.
Request 2:30. File is with 2:30.
Yes.
37, BS Prasad.
Madam, counsel for the appellant submits that needful is done. That is to verify if office objections are complied with. List for orders. ಆಯ್ತು, ಈಗ ಮತ್ತೆ 2 ಮಾತ್ರ ಕ್ಲಾಸ್ ಆಗಿದ್ದಾರೆ. Other matters at 2:30.
Serial number, my lord, 21 in the second list. My lord, 1 week accommodation is required, my lord, to place certain document. But offense alleged is 504 and 506. But against, there was a matrimonial dispute between
He
husband.
said he is ready.
I asked for time, the
Morning, when I insisted, he said, I am ready, pass over the matter.
My lord, we in fact wanted to place certain
You
documents and additional grounds.
Praying for time, he is engaged senior counsel.
No, my lord, only thing is I only told him to take time because my lord, certain grounds were not raised and the documents were not placed. That is the reason why I told him. Not your lordship, my lord, may extend the interim order and 2-3 days time may be
That is
granted.
the difficulty.
Now, that is what he told me. Then I said, if take pass over, we'll argue the matter. Only the offense is, my lord, 504 and 506. There are civil dispute pending between the parties. That has not placed on record. That is the only difficulty.
You are responding.
My lords, 504 and 507 is already, the charge sheet is already filed.
Respondent was opposing the.
All that I'm praying is, my lord, only 2-3 days accommodation to place the record, my lord, the material on record, civil disputes and other disputes, my lord, between the parties. Lord, the complainant is father-in-law, petitioner is, my lord, son-in-law.
Whatever it is.
My lord,
based on merits of the
interstate
case.
dispute between the.
6 years ಆಗಿದೆ, ಈಗ ನೀವು additional document, additional
Lord,
grounds.
this petition is of the year, my lord, 22.
22, 22, yes.
That is only,
Years at least.
some in between, my lord, mediation has taken place,
So I
everything
think
has been
None
taken
of the
place.
mediation they have attended, my lords. None of the mediation they have not attended. And now the NCR has also been filed as FIR. Can I submit this memo
That
which
senior
is?
advocate appears for the petitioner
Excuse me.
and prays for time on the ground that additional documents were traced and he wants to
Madam.
raise additional grounds in support of his contention. Then counsel for respondent number 2 opposes grant of any adjournment. Then counsel for the petitioner undertakes to do needful and address his argument on the next date of hearing without fail. Submission is placed on record. List on.
Interim order may be extended.
Interim order is extended, subject to the condition that the counsel for the petitioner addresses his argument on merits on the next date of hearing. Yes. Subject to condition. I can.
Late.
Next.
Madam. D2. D2.
12, 11. Again. Copy serve
Madam. Madam, 2:30 na, so 12:00.
ಆಮೇಲೆ ಮೊನ್ನೆದು ಅದು ಮೊನ್ನೆದು ಅದು ಒಂದು date ಕೊಟ್ಟಿರೋಂಥ ವಿಧಾನ ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೈತಲ್ಲ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್.
Court officer. Court officer.
ಸರ್ ಹೇಳಿ.
Court officer.
ಸರ್ ಹೇಳಿ.
ಇದು madam, ಇದು ನಮ್ದೇ first matter. Passed over 32.
Serial number 32, list 1.
List 1. Madam.
ಸರ್.
ನಮ್ದೇ first matter 230.
ಎಸ್ ಸರ್.
Hello.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
ಎಸ್ ಸರ್.
Madam, ಸ್ವಲ್ಪ loud ಆಗಿ ಮಾತಾಡಿಮ್ಮ. Thank you.
Sir, audible?
Yes, now you're audible. Yes, indeed. Yes, indeed.
Yes, sir. At 2:30, it is your first matter.
Thank you very much, madam. See the elderly gentleman sitting here, Air Marshal. ಅವರೇ ಕಂಪ್ಲೇನೆಂಟ್ ಪಾಪ ಬೆಳಗ್ಗೆಯಿಂದ ಕೂತ್ಕೊಂಡಿದ್ದಾರೆ 9:30 ನೋಡಿ ಅಮ್ಮ ಪಾಪ.
ಅದು ಡಿಸ್ಕಷನ್ ಆಗಿದೆಯಲ್ಲಪ್ಪ ಬಂದ್ಬಿಡ್ತಾರೆ ಬಂದ ತಕ್ಷಣ ರೀಚ್ ಆಗುತ್ತೆ ಬಂದ ತಕ್ಷಣ ರೀಚ್ ಆಗ್ಬಿಡುತ್ತೆ ಇವೆಲ್ಲ ಒಂದೇ ನಿಮಿಷದ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ಅವಾಗೆ ಕೇಳೋದಲ್ಲ ಸರ್ 19 ಪಾಸ್ ಓವರ್ ನಾವು ಸುಮ್ಮನೆ ಸಾಕು ಕೊಡ್ತಿದ್ವಿ ಕೊಡ್ತೀವಿ ಒಂದು ಯಾವ್ದಾದ್ರು ಸ್ಟಾರ್ಟ್ ಆಗಲಿ ಕೊಡ್ತೀವಿ ಯಾಕಂದ್ರೆ ನೀವು ಡೇಟ್ಸ್ ಎಲ್ಲ ಬರ್ಕೋಬೇಕು
Matter pertaining to Kalburgi bench, non-compliance of office objection for fifth time, serial number 1, M.A. Jagirdar.
Counsel for the petitioner is absent, no representation. The matter is listed for the fifth time for compliance of office objections. Even in the last date of hearing, there was no representation. Fifth time. Order sheet dated 22/10/2024 reads as in that. In spite of this, there is no compliance of office objections. Petition is dismissed for default. Next.
Pass over matter. List 1, serial number 27, Rajaram.
Counsel for the petition, appellant is absent, no representation. Even in the matter is passed over twice and was only called at 2:45 PM. Order sheet dated so and so reached as under. In spite of that, there is no hockey dismissed. Next.
Serial number 32, Joshua Hudson Samuel, Arvind Babu.
Your Lordship, I am appearing for the petitioners. I had submitted this morning with regard to my colleague also was there. The matter is now passed over before the lower court. This is a matter which is very unfortunate. The prosecutor had treated the Mercer witness as a seizure witness and the seizure witness as a Mercer witness. Both are Parsi ladies, and this pertains to the Parsi symmetry. There was an incident which took place wherein the accused had desecrated the prayer hall in the Parsi symmetry. I came before this court, the High Court. I obtained an order wherein I was permitted to conduct my ceremonies. This is a Parsi symmetry. And I had filed a criminal complaint that is at page number 43. Based on the complaint, an FIR came to be lodged, and thereafter the charge sheet came to be done. Unfortunately, what has happened is that the ladies didn't understand Kannada because they are Parsis. As a result of which, there was a confusion. I filed an application under 311, permitting me to recall the witnesses and then ensure evidence is recorded to that effect. And the gentleman here is the complainant, Air Marshal Mr. Batha. He is 80 years old. Diligently, he is following this up.
No, why actually PWs 1 to 3 are to be recalled?
Only in order to ensure the defect which has been caused by way of the public prosecutor treating them, mixing them as seizure witness and Mercer witness. When in fact it should be the other way around.
Yes, what do you say?
First, my lord, kindly take page number 40, my lord, of the lower court order. It is not as simple.
Can you please speak into the mic, sir, so that I can hear also, if you don't mind.
Switch on the mic.
It is not as simple as my learned friend is putting it, my lord. The state is the complainant is being represented by the state, and state public prosecutor is representing them. Application, if at all, has to be filed by the public prosecutor. He has not filed any application. Now the complainant himself has now come forward and filed the application.
The impugned order.
Impugned order, my lord, ink page 40, my lord, para 7.
It starts from 39.
Sir, please wait. Page 7, my lord. Para 7, ink page 40. As stated, Supra, this is an application filed by the senior public APP praying to recall 1 to 3 to adduce certain additional facts, and PW2 and inadvertently depose their evidence, Caesar major witness instead of spot major witness as stated in the application. I have gone through the materials available on record. The evidence of PW1 and 3. On perusal of the evidence of PW1, who is the complainant herein, he has adduced his evidence
in detail on 3/3/2018. Subsequently, he has been cross-examined on 6/6/2018 and 21/7/2018. Further, on completion of the cross-examination, the very same senior APP has submitted that he has no re-examination, which in turn demonstrate that there is no ambiguity in the evidence of PW1. If at all there would have been any ambiguity in the evidence of PW1, under those circumstances, definitely the APP would have re-examined the witness on the above date. Further, it is pertinent to note that on the perusal of the detailed cross-examination made by the counsel for the accused, there were some admission taken by the defense counsel in their cross-examination from the mouth of PW1. Likewise, the prosecution has examined CW3 and CW4 as PW2 and PW3. These witnesses have turned hostile, and the very same senior APP has treated PW2 and PW3 as hostile evidence and sought for permission of this court to cross-examination PW2 and 3, which with the permission of the court, he has cross-examined PW2 and 3, wherein in the cross-examination, PW2 and 3 have denied the suggestion put to them by the learned counsel, by the learned APP during the course of cross-examination. When such being the case, once again recalling PW2 and 3 to adduce additional evidence is unknown to law. Further, as stated Subra, in the present case on hand, PW1 has been chief examined and cross-examination fully. Further, the entire application, nowhere it has been specifically stated that what was the ambiguity put forward in the evidence of PW1 and the reason PW1 wanted to be recalled and to give further evidence and has not been explained. In the absence of the above said fact, simply PW1 to 3 cannot be recalled and permitted to give additional evidence. Moreover, PW1 to 3 are not the prudent witness and PW1 and 3 are educated witness. Per contra, prima facie, it appears that the prosecution wants to fill up the lacuna in their case, which they all, as such, they intend to recall PW1 and 3, which is 1 to 3, which is not permissible in the eyes of law. The learned senior APP has relied on two decisions. I have gone through the said rulings. In fact, the facts and circumstances of the present case,
Yes.
my lord, subsequently, my lord, they filed one more application for recalling. That application came to be dismissed. That was challenged before this honorable court. This honorable court, my lord,
Subsequent application to recall?
PW1.
For the purpose of marking the
Sir,
document.
it is our full power. I will finish it.
Only PW1.
PW1.
Huh.
And this honorable court, my lord, the coordinate bench of this honorable court allowed the petition with a direction that it should be completed on the specific date. And there is a direction, my lord, that no further applications for recalling should be filed. At every stage of the case, my lord, when the case is posted for judgment, they file an application. When the case is posted for arguments, they file an application, only to fill up the lacuna. The application, my lord, filed by the prosecution is dismissed. If at all they are agreed, the prosecutor has to file the revision, not the complainant. Moreover, my lord, this cemetery belongs to the government, and as a private person,
All on facts and merits of the case.
merits of the case. And secondly, my lord, this submission made by my learned friend that he does not know Kannada and therefore she has misunderstood the question, my lord, would cause aspirations on the court as well as the PP, my lord, because the court and the public prosecutor were there when she was examined. And after she understood the case and turned hostile, my lord, he cross-examined her. And the application is filed in the year, my lord, of 2019. Now, after a lapse of 6 years, my lord, recalling the PW1 to 3,
That to fill up the,
Examined, when examined,
who, my lord?
PW1.
PW 2019, my lord. 2018, my lord, 3/3/2018.
Chief examination.
Chief examination, cross examination, my lord, was on 6/6/2018 and 27/7/2018.
And by virtue of this order again recalled,
Yes.
when examined.
Recall, my lords, and I have already produced the documents. It has been marked
I will
also.
come back. I will come back, sir.
That is, my lord, on 27th, my lord.
No, order is dated 13th September.
1510, my lord.
Huh?
1510 it was recalled. 2210 I cross-examined. Now the case is posted today for reply of the prosecutor. Earlier occasion also, my lord, when that application was filed.
Now, your argument is complete?
Yes. When the case was posted for judgment, my lord, they filed the application with impugned order is honorable court allowed the application.
That's all?
That's all.
Yes, what do you say?
Yes, I only have to say this, my lords. In so far as the fact that PW1 was sought to be recalled, subsequently permission was granted by this honorable court for the purpose of recalling PW1. The documents of the orders of this court, including content, has been marked. And the copy is there, my lords. I'll ask my learned friend to just place it
Yes,
before.
sir. These facts you are not disputing.
Yes. I am only talking about PW2 and PW3, who are the spot witnesses and was a witness.
Completely turned hostile. They never.
Because the thing is, both of them were ladies. Both of them were ladies.
Maybe,
they were
sir.
not aware of what was the question being put forth by the
Sorry, sir, they are
prosecutor.
examined. They are not examined before the police station. They are examined before.
They were done it before the court. They were done before the court. There was a mistake because they said that there was a mistake. I have nothing to say.
If your submission is to be accepted, I should also accept that the court was a mute spectator.
My ladyship, I can
Do you
only
mean
say
to say
this.
so?
No, I can only say this. I can only say that the court never even asked them as to whether they were able to understand the question.
What the prosecutor was doing there.
That is something which I don't want to comment. I don't want to comment, though I was given the permission. I've been prompting him. The court never refused. I don't want to make anything at this point of time. I'm only saying, give me an opportunity. Only for the purpose.
The judicial officer will be there. If they have not understood the questions, definitely the witnesses will look at the.
My ladyship, I fully agree and I fully endorse whatever is falling from the court. I am saying that let not that be a travesty of justice, only on the ground saying that the prosecutor had mistaken the witnesses to be the spot witness.
Already at your instance, the similar application is allowed by the coordinate bench of this court. Recently, that is.
It is for a different ground. That is for marking the original documents or the certified copies of the orders of this court. Kindly, Mr. Maruti, please give it to the judge.
You cannot seek the calling of PW1 in piecemeal matters.
I don't want piecemeal. I'm only asking with regard to PW2 and 3. I don't want PW1 also. I don't want PW1, only 2 and 3. Otherwise, there's nothing which remains in the case.
Where is the evidence? Have you produced their evidence?
I have produced evidence.
Order sheet, the learned judge has spelled out in the order. Page para 7, para 8, Miller. Page 42. 41.
Nothing has been called out, sir.
Page 8, para 8, Miller. If further it is pertinent to note that on the hostile anta helidare PP or cross examination madidare.
The deposition is not produced.
I'll place a deposition. It is 2 lines, 2 questions asked, and then they are treated as hostile. I'll place it before the court.
Where is it? You have not produced?
No, I have not placed it here. I will place it before the court.
You place it.
In the meantime, stay there.
Counsel for the petition.
The only thing is, in the meantime, my ladyship, I would request this court to direct the trial court to defer it by 2 days.
place additional documents in support of his contention. Please notice that the coordinate bench of this court has considered similar petition and had passed the order on 13/9/2024 in view of the circular number so and so. Office is directed to place the matter before the appropriate bench this term. It will be placed before the same bench in view of the circular.
But according to the roster, my lord, it has to come before this one.
Huh?
According to the roster, it will come before.
There is a circular, sir. When a similar petition is considered by the bench, the same bench has to consider.
And leadership, can it be deferred? The trial court be directed not to proceed to the matter?
No such directions, sir. No such directions.
No, but what do I tell the court today at 2:30?
Yes. Next.
I have to make a submission before the court. The matter is passed over at 2:30, at 3 o'clock. Can I at least ask for 2 days?
No interim order, no
No,
direction.
I don't want an interim order. At least let the trial court not proceed to the case for 2 days.
No grounds, sir. No grounds, madam.
No, if the matter is proceeded for postal for judgment, my petition will become in.
Your prayer is rejected. If you want, I can place it on record.
Please don't say that. At least I will go and beseech the court. Very good.
Yes, next.
Serial number 35.
On Monday, my ladyship, if it is okay.
Not Monday, sir. The court officer will give the date.
Serial
Very
number
good.
35, MS Chandrasekhar Babu.
35. What is the objections? 3 and 4 are the co-accused.
Para 5 of the.
3 and 4 are the co-accused.
How? 1 and 2.
Who is the appellant? Complainant.
A complainant is the appellant. Para 5 of the my petition have clearly stated that the appellant.
1 minute.
Please.
Which is the order you are impugning?
Annexure M in page number 28 notes. Order passed by the.
No, that is the judgment passed against
Oh, judgment
respondent
passed.
number 1 and 2.
How?
Acquitting them.
How? In this case, what had happened, a para 5 of the has clearly stated that the appellant states that the FIR dated 13/3/2015, the name of the Chetan alias Dhanush and the name of the Venkaranappa, the accused 1 and 2.
Please tell me to understand the facts.
Please.
Respondent number 2 and 3 are arrayed as accused number?
Accused number 1. Accused number 1 and 2. Eitherly criminal appeal, I'm saying. In the appeal, in the CC also,
Sir, in
they have
this
been 2 and 3.
In this appeal, respondent number 1 and 2.
1 and 2 are the accused number 2 and 3.
1 and 2.
How this?
Right?
How?
Respondent number 3 and 4
3 and 4
are accused number 3 and
accused number 3 and 4.
correct?
How? What had happened? FIR was filed. FIR was filed in the name of all the 4 accused. Subsequently, it was dropped. Dropped by the discharged by the police. FIR, they have deleted the name of the saying that Dhanush alias.
Filing the charge sheet. They were dropped. The trial was held only against accused number 1 and 2.
No, trial was euro against 3 and 4. Chetan and Venkaranappa have been discharged. Jaychandra and Shilpa have prosecuted.
ಹೆಸರು ಯಾಕೆ ಸರ್ ಡೆಸಿಗ್ನೇಷನ್ ಹೇಳಿದ್ರೆ ಈಸಿ
I'm sorry. I'm sorry. I'm sorry.
You are confusing the court also.
Please, madam.
ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೆ ಇನ್ನೂ ಈಗ clear ಆಗಿಲ್ಲ
in the para 5 and also in the complaint.
Forget about the paras.
Please.
I am asking you who are the rank of the accused.
Accused. Please, madam.
ಈಗ ಪಾಸ್ ಓವರ್ ಆದ್ರೂ you are
ಇಲ್ಲ,
not in
ಇಲ್ಲ,
the
I'm
position to
clear.
tell.
Well, I am clear. Annexure A, the complaint, it is clearly, complaint was given against Venkatronappa, Chetan, and also accused number 1 and 2, that is, who have been acquitted. In the earlier complaint, in the 13/3/2023, FIR was filed against all the 4. But subsequently, the accused number 3 and 4 have been discharged. The fact remains that accused number 1 and 2 are the main culprits who have made Galata, and the nature of the offense is that 323, there are serious offense, non-bailable offenses, my lords. In the police station, they have enlarged on bail. That is questioned before this honorable court, my lord. They have no authority. Even in the prosecution, 70, there are 70 times the exemption applications have been filed by the accused number 3 and 1 and 2, who have been acquitted. The allegations are serious in nature, and wound certificate, hospital certificate, wound certificate, everything have produced.
Sir, please wait for some time.
Please, I'm sorry.
When I could not get the assistance from you, please let me understand. This respondent number 3 and 4, Dhanush and Venkatramanappa, they were dropped while filing
They
the
are,
final.
earlier they are dropped.
No trial was held against them.
No trial was.
Then why they are arrayed as respondents?
They are the main culprits who have made Galata in the.
So what is the remedy available for you? How can you prefer an appeal against the impugned judgment when they were not tried before the trial court?
Maybe deleted minutes.
Huh?
Wanted to
Sir,
take in
you
appeal.
should apply your mind, sir.
I have taken appeal.
Then?
So far as 3 and 4 are concerned.
ಅವ್ರನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
1 and 2.
They are not the necessary parties.
1 and 2 they have.
1 and 2, okay. I am asking you about the office objections.
Maybe delete martin.
Told. Heard and counsel for the appellant on office objection regarding arraying of accused number, respondent number 3 and 4 in the appeal. It is noticed that the impugned judgment of acquittal dated 13/4/2023 was passed by the trial court only against respondent number, only after holding trial against respondent number 1 and 2. Respondent number 3 and 4 were not tried by the trial court. They are not parties to the impugned judgment. Hence, office objection is upheld. Upheld. Counsel for the appellant is directed to delete the names of respondent number 3 and 4 and to file the amended cost title. You delete their names in the cost title and file amended cost title.
Much okay.
These two, serial number 6. CH-24.
Amendment casted ready.
Amended cost.
And counsel for the appellant filed amended cost title. Amendment ಆಗಿದೆ. ಮಾಡ್ಬೇಕು ಫಸ್ಟ್ ಅದನ್ನ ಮಾಡ್ಬೇಕು. First amend the cost title immediately. Amend ಮಾಡಿದ್ಮೇಲೆ ಇದನ್ನ counsel for the appellant he has amended the cost title and filed the amended cost title. That is to verify. Next.
Serial number 7, Nagesh.
For appellant, my lords. My lords, IA number, I apologize, my lord. First of all, I apologize, my lord. IA number 1 of 24 is not yet allowed, my lord. It's only directed to file death certificate, my lord. I have,
How you can make submission repeatedly saying that IA is already allowed, already allowed?
I'm sorry, my lord. There's miscommunication between me and my counsel, my lord. My colleague, my lord. I'm sorry, my lord.
ಇದೇನಿದು 1 of 2023 ಏನು 1 of 2023 ಏನಿದು ಏನದು what is IA 1 of 2023?
That is implementing application, my lord.
What happened to that?
That is, appellant is dead, my lord. To bring LRS, we have filed the implementing application, IA number 23, my lord. Then we did a not press, my lord, and we'll file a fresh application regarding IA number 4.
Why it was not pressed and why fresh application?
Because, my lord, in the affidavit, there was some miscommunication, my lord. Some correction in the affidavit, my lord. So we are not pressed it, my lord, IA number 23.
When appellant died?
One second.
What is IA 1 of 2024? It is never stated.
On
in
31/8,
the
my lord.
Huh?
On 31/8, my lord.
Where you have stated in the, either in the application or in the affidavit?
My lord, I have produced a death certificate, my lord.
Have you stated in the affidavit?
No, my lord.
Then I will dismiss the application.
My lord,
Not necessary.
my lord, 1 week time, my lord. Phrase time, my lord, 1 week, and I'll file in the next date, my lord.
Counsel for the appellant on IA 1 of 2024. Filed for bringing the legal representatives of deceased appellant. Neither in the application nor in the affidavit, there is reference to the date of death of the appellant. It is noticed that IA 1 of 2023, a similar application in IA 1 of 2023 was filed, and subsequently the same was dismissed as not pressed. Thereafter, the present application was filed, and even in that application, the material fact as to when the original appellant died is not mentioned. Hence, IA 1 of 2024 is dismissed. Sole appellant is already dead, hence the appeal is abated. This. Next. Dismissed as abated. Next.
Serial number 12, Vishnu Hegde.
Recalling the order, my lord, the non-compliance of the office objection, it was dismissed.
Hmm.
The copies were not submitted, my lord.
Hmm?
Copies of the appeal is not submitted to issue to the respondent.
Hmm.
It was dismissed, my lord. I filed the IA.
What is wrong in it?
I agree, my lord.
No, ಏನಿಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ಎಲ್ಲ ಇಂಥವೇ ಇದಾವೆ. Continuously on 3 dates of hearing, there was absent, there was no representation.
File was misplaced.
You must show the reasons. 3 days, continuously for 3 days, they're absent. There cannot be any justification.
Amount is, my lord, 72 lakhs. The
The-
check
we are not concerned about it,
relating
whether
to
it is
that, it was
72 lakhs,
dismissed,
52
my lord.
crores.
Dismissed, my lord. The other side has taken the contention that signature is forged. But in that, the FSL was sent and it is proved that the signatures are genuine.
How
At
is
that
concerned
moment,
about the merits of the case, sir?
no, I agree. I'm not saying that's this one, my lord.
Is
Those
it-
things will not happen further.
ಏನಿಲ್ಲ, ಏನಿಲ್ಲ.
Kindly, my lord.
Sheer negligence, no, nothing.
No, my lord. That is the.
ಇದೇನು ರೆಸ್ಪಾಂಡೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆ?
ಇಲ್ಲ ಅದು ನೋಟಿಸ್ ಆಗಿದೆ, ನಾಟ್ ಯೆಟ್ ಸೆಂಟ್ ಮೈ ಲಾರ್ಡ್.
Third learned counsel for the, what is the reason assigned by you?
My lord, file was misplaced and unable to
Where is
get
the
the
file now?
certified copy.
Where is the
I
file?
applied and got it, my lord. ಇದ್ರಲ್ಲೇನೆ ತಕೊಂಡೆ, ಕೋರ್ಟ್ನಿಂದಾನೆ.
Third learned counsel for the appellant on IA 1 of 2024 filed for recalling the order dated 27/6/2024, dismissing the appeal for non-prosecution. The impugned order discloses that the learned counsel for the appellant was absent continuously for 3 dates of hearing. I am not satisfied with the grounds made out in the affidavit accompanying the application. However, in order to provide one more opportunity to the appellant to prosecute the appeal, I deem it appropriate to allow the application subject to payment of cost of ₹5,000 to be deposited with High Court Legal Services Committee within 7 days from today, failing which appellant is not entitled for the benefit of this order. IA is allowed subject to cost of ₹5,000 to be deposited with High Court Legal Services Committee
Legal.
within 7 days. Yes,
And I will take the steps also, my lord.
I don't know. ನೋಡೋಣಂತೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆದ್ರೆ I will.
First deposit ಮಾಡಿ ಬನ್ನಿ, conditional order.
Yes, ma'am.
Only after deposit of the amount, you are entitled to do anything.
But
Yes,
legal cell authority.
committee, High Court Committee.
Serial number 15, C.R. Rajagopal.
Petitioner, my lord. He's 68 years only, my lord.
75 ಅಂದ್ರೆ
ಇಲ್ಲ my lord, sorry, extremely sorry, my
ಸುಮ್ನೆ
lord.
ಏನೋ ಬಾಯಿ ಬಂದಿದ್ದು ಹೇಳೋದಾಗಿದೆಲ್ರಿ.
ಇಲ್ಲ my lord, sorry,
ಹಾ?
extremely sorry, my
ಏನು
lord.
ಸ್ಯಾಂಕ್ಟಿಟಿನೇ ಇಲ್ಲಲ್ಲ submission before the court ಅಂದ್ರೆ.
Sorry, my lord, extremely sorry. It is 68 years, my lord. I have corrected
75
it,
ಅಂದ್ರೆ 70 ಅಂದ್ರೆ
my lord. Sorry, extremely
I
sorry.
have to show it to, it is 68.
Yes, my lord.
ಅವ್ರು ನಿಮ್ ಕ್ಲೈಂಟ್,
Yes, my lord.
ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿನೇ ಇಲ್ವಾ?
Sorry, my lord.
ಏನ್ ಸಾರಿ? So, since there is delay of 115 days in preferring the appeal, same is, since there is delay of 115 days in preferring the appeal, IA 1 of 2024 is filed. Since there is a inordinate delay, the same is to be considered along with the merits of the case. Hence, list the applications to be heard along with the appeal list for.
My lord, one submission, my lord. Kindly issue by hand, my lord, the notice.
Notice issue ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು. You convince the court about merits of the case. ಆಮೇಲೆ ನೋಡ. ಯಾವುದನ್ನು ಕೂಡ. ಎರಡನ್ನು admission along with merits of the case. Call for trial court record, list for admission. Yes.
Serial number 19, Mr. Manjesh Vishwanath Shetty.
To appear for the respondent in this case, my lord.
Hmm.
Raise one time, my lord.
ಏನಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Appellant has not addressed the argument.
Thank you. Actually, I filed the NOC wakalat from the.
ಯಾರಿಗೆ?
1 week time may be granted, not so that I can positively address the argument, my lord. 1 week time may be granted.
And possibly ಅಂದ್ರೆ, if not possible?
No, positively, positively I said. Positively I said.
Learned counsel for the appellant is absent, no representation even when the matter is passed over twice. Huh? Either appellant. You are representing the, please unmute your mic, sir. You are not audible. Please unmute.
Sir, not audible, sir.
Learned counsel for the appellant is present through VC. Due to technical reason, he is not audible. Learned counsel for the respondent, raise for time. The appeal is of the year 2015. Noticing non-service of notice on the respondent. Warrant was issued against him. However, the same was came to be recalled. Today order dated 16/10/2024. In spite of that, the counsel for the respondent is seeking time. I do not find any reason to adjourn the matter, however, to afford final opportunity this time. See, no further adjournment.
Please.
Either at your instance or at the instance of the appellant.
Great. ಯಾವಾಗ ಡೇಟ್ 2 weeks. ಮೇಡಮ್ ಮಂಜೇಶ್ ಅಂತ ಇದ್ರಲ್ಲ ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಇದೆ ಮೇಡಮ್, ಡಿಸ್ಪ್ಲೇ ಆಗುತ್ತಾ?